Extended my lord, may I be granted your lordship kindly mention a matter for inclusion in the list, my lord.
Item 1, I am for the state, my lord.
My lord, we have, pursuant to your lord's direction, my lord, we have intimated the office of the additional district magistrate. My lord, this is the intimation.
Who is for the state?
I am for the state, my lord.
Oh.
My lord, I talk with DM, my lord. They have received the mail, but through mail, and it's praying for some time because the election is going on, my lord. Otherwise, lordship can direct the local police station, OC, to physical presence of the principal of that school.
Earlier, my lord directed me to, my lord, inform the BDO. So the BDO intimated the school authority. Even then they are not coming. So, my lord, as my learned senior suggested, my lord, let the OC inform the school authority. The issue is, my lord, only, my lord, transfer certificate.
Did the block development officer inform?
Yes,
Inform.
yes.
Inform. I
have informed the school.
Earlier, my lord. The
Earlier.
lordship directed me to, my lord, inform through the BDO. We did that. The BDO informed the school authority.
Now, what this district child protection unit is doing?
My lord, district child protection unit, my lord, intervened into the matter as per your lordship decision. And earlier, on the earlier occasion, your lordship directed me to inform the district child protection unit again so that the issue of transfer certificate can be resolved. So that, my lord, the ADM has probably, my lord, through the BDO intimated the school authorities again.
When is the admission going on?
My lord, admission is, my lord, we have already tried to apply for another school. My lord, the mother herself, my lord, on 16th of April, my lord, submitted this application before the principal.
my lord, principal presence is required.
What is the child protection unit is not passing any order in respect of the application?
Well, I talked with morning before 10 minutes ago with DM by telephonic. Well, DM talked the video file a report regarding the issue.
The child protection unit has to pass an order where an application has been filed by the applicant seeking for issuance of a transfer certificate in favor of her son.
Well, time is required because of
what time? The child protection is not functioning right now.
He is the election officer.
No, is the child protection is functioning or not functioning?
DM talked me, but some
for election, the admission of the child will be withheld. You tell me.
No, withheld.
Then
pass the order by the
they are the authority in the district. They will call the school authority and ask from them why this has not been issued.
Madam, receive on 16th April. Today is 20. Some time is required. On 23 is election is going on in North Bengal.
23. So 20 after 23rd you can do it.
7 days time is required.
After 23rd. Tell the advocate for the state, Mr. Chattopadhyay.
Led by Mr. Chattopadhyay.
You are Mr. Mondol.
I am led by Mr. Chattopadhyay. I am by the Sobbosachi Mondol.
Mr. Sobbosachi Mondol, and an advocate for the state, submits that he has already communicated with the district magistrate Dokhin Dinajpur pursuant to order passed by this court on 6th April 2026. He informs the court that some time is required since election are scheduled on 23rd April 2026. The election of West Bengal Legislative Assembly is scheduled on 23rd April 2026. Place this matter on 29th, 30th April. Thursday, under the same heading to be mentioned.
Grateful.
You just find out that the district protection child unit can very well within its jurisdiction call the school authority and resolve the issue. Not
Grateful.
a matter which the order has been passed in writ court.
Grateful.
Just find it out. Enough.
Who I am for the petitioner. Pursuant to your lordship's direction, my lord, the affidavit in opposition to the CAN application has been served upon us by email, and we are filing our reply, and that has been served upon them.
Lordship, I am appearing for respondent 325.
But this is the Ramakrishna Mission matter, my lord, where I had filed an application seeking addition of party, and they had sought for leave before this court
Addition
to-
of whom?
addition of parties with respect to certain persons who are working in the same category.
Oh,
Lordship, before my learned friend could start, can I ask for a 10-minute passover, my lord? Mr. Yash Singhi is appearing in the matter. He is stuck before court 37. A 10-minute passover, my lord.
আজকে তুমি তো affidavit oppositionটা ফাইল করবে তো?
হ্যাঁ, করে দিয়েছি।
করে দিয়েছে।
হুম।
Both sides have filed the affidavit in opposition pursuant to your lordship's direction on the 6th of March. They were supposed to file their opposition to the writ petition also. But such liberty was granted by your lordships that after this applications, they would be filing their opposition to the writ petition. If your lordship kindly sees the 6th of March order, paragraph 5.
so let this CAN application be disposed of at
Yes,
the
yes.
second. Where is he?
Lordship, asking for just 10 minutes passover, my lord. He will be here.
Okay. Your opposition? Your reply?
Yes, we
Where
have
is
filed.
your opposition?
Lordship, opposition I have handed up.
এটা যখন পাস ওভারে ডাকা হবে তখন দেখুন। You keep this reply with you when the matter will be taken up. I'll pass
But
it.
I have a difficulty in the second half, my lord. Because a matter has been fixed in court number 24.
Okay. After
But-
10 minutes.
My lord, if it is fixed tomorrow or Wednesday also, we will be here.
If that be so, then I take the affidavits on record and thereafter fix a date for hearing. That can be done. Tough. Affidavit in opposition filed on CAN Act. CAN 1 of 2025. Affidavit,
But that would be taking, my lord, hearing matter, if your lordship kindly fixes up any time and date, my lord, it's a short matter relating to addition of party only.
this will appear under applications, not hearing.
Yes, my lord. Any date, my lord.
This affidavit of service in relation to CAN.
Yes, yes.
Affidavit of service filed on behalf of the petition is taken on record.
And to the application.
Affidavit in opposition
Hmm.
to the
Uh-huh.
application for addition of party filed by the respondent.
File.
This respondent is Ramakrishna Mission.
Yes, my lord.
Respondent number?
325.
The petitioner filed the application for addition of party. It is the petitioner who has filed the application.
Correct. No, the respondent in writ petition
325.
3 to 5 is taken on record. Affidavit in reply to the affidavit in opposition filed by
The responsible, we have handed over.
ওই যে দিলাম এখন is also taken on record on the joint prayer of the parties. List this matter. Copy the application. One. তাহলে
If it tomorrow, my lord.
not to.
My lord, Wednesday preferably with that, if it's convenient to my lord.
30 তারিখে রাখো 30 তারিখে তো ট্রান্সফার তো 30th April.
Grateful, my lord.
All right.
Well, I'm for the contempt, my lord. Well, I'm filing my compliance report.
May I have a copy, my lord?
Yes, yes, I'm handing over.
But I shall file an exception, my lord. Your
What
lordship
exception? First, go
direction.
through that. What is
Yes, I know,
Your lordship may recall, your lordship pleasure was to direct the contemptor to take an inspection, prepare a sketch map, and dispose of the complaint in terms of section 23 of the. That has been done, my lord. A reason order has also been communicated to the petitioner. Now, my lord, any cause of action, my lord, that will emanate from that rescind of order, my lord, a fresh writ petition has to be filed.
Where
my
is the order?
lord. Only rescind order, my lord, has been annexed. My lord, kindly come to page 12, annexure P4. Order dated 16th April 2026.
Affidavit of compliance filed on behalf of the petitioner is taken on record.
My lord.
Learned advocate for Mr. Ranjan Kali, learned advocate for alleged contempt, submits that in compliance to order dated.
My lord, my submission, my lord, not complied with your lordship.
Okay, you challenge that order.
There is a
No.
lordship kindly
Compliance to order is 5th August 2025.
procedure laid down by your
Passed in
lordship. That was
WPA 19413 of 2024. The alleged contempt has passed order on which date?
order, your lordship's order.
15th April
I-
2026.
Yes, 15th April 20.
Mr. So-and-so, learned advocate for applicant petitioner submits that the order has not been passed in accordance with the direction.
Procedure laid down by your lordship.
Okay. You know,
All,
inspection you have done.
Yes, yes, my lord. Sketch map also have annexed, my lord.
my lord,
That has been, my lord, in the order itself has been narrated, my lord.
did the inspection report.
But if he is
Yes.
agreed by the order, my lord, he has to challenge by of a separate writ petition.
That is correct, but
Learned advocate for the petitioner, applicant petitioner submits that the alleged contemner has not complied the order of this court strictly. Upon going through the affidavit of compliance, it is found that upon inspection, a sketch map has been prepared and thereafter the parties were called for hearing, and upon hearing, the order has been passed. Since order has been passed by the alleged contemner in compliance to order of this court, the contempt application being CPAN 1855 or 2025 stands disposed of.
Grateful to your lordship.
Next,
My application, my lord, on last occasion, affidavit of service has been recorded. Despite repetitive service, none appears for the alleged contemner. May I pray before your lordship to issue the rule, my lord?
who is the alleged contemner?
Gram Panchayat Pradhan, my lord, of Sikarbali Gram Panchayat.
On thirteenth April 2026. Now, the affidavit of service filed on 13th April 2026 shows that the alleged contemner has been duly served with the contempt notice. The matter was taken up on 13th April 2026, but since none was present on behalf of the alleged contemner, the matter was adjourned for ends of justice. Despite service, none appears on behalf of the alleged contemner. Rule be issued.
Grateful, my-
Date bolo. 19th May 2 p.m.
Grateful, my lord.
For the petition, my lord. Earlier occasion, I filed the affidavit of service, but it did not show that actually the
Service was affected or not?
service was affected. My lord, this is another affidavit.
Affidavit of service filed on behalf of the petitioner applicant is taken, Devnath Babu. Applicant is taken on record. It is found that service has been effected upon the alleged contemner. Despite service, none appears on behalf of the alleged contemner. The rule issue করুন। হবে দেবো। Which panchayat?
Not
বুঝলি নাই?
our Gram Panchayat. Our Gram Panchayat.
19th May.
The rule
250.
is issued, my lord.
Rule issued.
Seven, I am for the petitioner, my lord. Non-compliance of my lord order date 10th November 2025. First time, my lord.
Issue notice.
না ডাইরেক্টর
হ্যাঁ আছে।
ওয়ান
Who is this?
তো কপিটা সার্ভিস করি
বললি দিয়ে দেবো আমার কাকা।
A disability certificate.
Xerox করে আর দিই।
Who is the alleged contemner?
My lord, DIN Director of Pension Provident Fund.
Two.
My lord, namely Gautam Samanto and এই নতুন নামটা কিছু জানো?
রণদীপ
না আমি তো না
চেঞ্জ হয়েছে বুঝলেন এটা কারেকশন করে না
আমি নামটা জেনে করে নেবো।
Distance of PV Paschim Mednipur. Notice issue. After 4 weeks.
সেন্টার করে But Lordship, contempt number one, new complainant has been come. So Lordship, name has been changed.
Kindly give
Direction has
can
been
we leave? I just the DPPG director name will be changed. My lord, new complaint.
Their name is mentioned Randhir Kumar. I think Randhir Kumar is not a Lordship here. There's Lordship liberty has been given to the Lord amendment the Lordship cost item on the contempt number
Who is the
one.
new one?
Contempt number one.
Who is the new one? What is his name?
Pawan Kumar.
Pawan Kumar, Lordship, I don't know Pawan. He asked Lordship, who is the Pawan Kumar?
Is it a change?
I am giving the name Lordship.
This change is due to the election or
No,
it's a
no,
permanent
no,
posting?
Normally,
Just for from the another.
Give the name then. On the prayer of learned advocate for the petition applicant, leave is granted to correct or incorporate the name of Sri Pawan
Randhir Kumar to Pawan Gandeli. I think Lord, I Pawan Lordship, but his surname I am. I am Lordship here. I am giving name Lordship. Yeah, cost title amendment cost title.
আমি তোমাকে দিচ্ছি এক্ষুনি।
ওই তো নিয়ে নিয়েছে তো।
Doctor.
Item 12, my lord, I am for the petitioner. Matter is relating to take 2017 wrong question matter. My lord.
Date 2017.
Wrong question matter, my lord. The division bench directed to create a committee, and the committee's report is found that one
1 mark for wrong.
question is wrong.
2 weeks ago filed. Checking yes.
The board has filed a CAN application
Can আছে?
in CAN 1 of 2026. I don't know whether that has come to the record or not.
When did you file that application?
Why the
No, state আছে।
lordship 17th
17.
of April.
अच्छी बात करी।
Because this has to be counted in the record. Shukrobar.
Side করেছে?
Lordship.
The application is not showing in the computer. That's why it is not listed.
Oh. Then I'll take it up tomorrow.
Friday.
Okay, copy the.
Friday. Mr. Subhi Sannal, a senior advocate representing West Bengal Board of Primary Education, submits that an application in Can 1 of 2026. Can 1 of 2026. Friday.
No, my lord, may I, because they are also pressing, we are also, my lord, want to comply with that and to wash up our hands. My lord, may I give you losses copy in the meantime, take, my lord, let them bring that copy so that we can move it before your losses.
And tomorrow?
Tomorrow, all it is. Tomorrow সব আসবি তো?
না, ভোটে সব বেরিয়ে যাবে।
All it is.
আমরা কি
Since the matter in the, মানে showing in the cause list,
মানে অ্যাপ্লিকেশনের হেডিং এ অ্যাপ্লিকেশন শুধু মুভ করবে
application only.
অ্যাপ্লিকেশন হেডিং এ ওটাকে আনিয়ে নিন কালকে লিস্ট করে দেন হ্যাঁ নট টুডে
8 to 11, my lord. 8 to 11.
8, 9, 10, 11.
No, if one
this application order passed in this can will operate in 8, 9, 10, 11.
Well, even those matters which are not in the list, those will also be covered.
My lord, 8, 9, 10, 11, not today.
Not today. No.
My lord, I led by Mr. Random Chattopadhyay on behalf of the state.
Yes.
I'm praying for short passover, my lord.
What is this, man?
Lordship.
What is this?
Well, my lord, my senior is engaged in another court, my lord. That's why I'm praying for short passover, my lord.
Next to love.
I am for the petitioner, my lord. Under this matter related to issue certificate.
My lord, I'm appearing on behalf of the NIOS. I'm led by Advocate Shiv Shankar Banerjee, and on the previous occasion, we are directed to file a report. And the report I'm filing. Sorry.
What is this? Give a copy to him.
Yes, my lord.
You have given a copy?
Yes, my lord, already.
What is this matter?
My lord,
What is the matter?
the matter is, my lord, the petitioner already given the DLED examination from NIOS, my lord, and they passed successfully. But after pass, did not receive the certificate and mark sheet of the NIOS certificate, my lord. So therefore, this writ petition was filed, my lord, and the report is come, my lord. As per the report, I did not find anything that the petitioner will not get the certificate of DLED course, my lord.
Yes,
What is there in the report?
that lord's report.
So Vaishyu is appearing for state.
State lord. আমার আছে আগ্নি কাজ এটা আমি কেটে দিচ্ছি এটা দেখেন
Item,
Lordship, item
point number 5 goes against you. Point number 5 of the report, page 4.
Page 4, I say that as per announced recognition order such and such data such and such is the minimum eligibility criteria 50% mark has and it is equivalent to the action of those who do not fill the requirements shall be allowed to make provisional admission to the program of subject 50% mark before the, my lord, the petitioner is not obtained the 50% in HS, therefore the fill up the for senior higher secondary examination, and the senior higher secondary examination they also pass, my lord. So
When
this,
did you pass that?
yes, my lord.
When did you pass that?
After complete the DLED examination. This is the
Lordship, may I
point
please
they
your
may take,
Lordship?
my lord.
Lordship, firstly, when the notification came out, your Lordship, it was stated that you have to have an HS pass certificate. The ones who have 50% and up, they are eligible. The ones who have below 50%, during the course of the program, they can obtain the 50% marks, present the certificate, and the course ended on 31st March 2019. Within that period, you present the certificate, we will give you a result and the qualification certificate, everything. Now, what has happened thereafter in 2022, your Lordship, another notification came, which is annexed to the writ petition, which says that this criteria of obtaining 50% marks in HS is exempted with. But you have to have a HS pass certificate at the time when the program had started, when you had enrolled in 2017. Now, as for the petitioner, she had the petitioner had not uploaded any certificate.
So how he has joined the program then?
Lordship, there is a guideline which says that the principal of the school and the state nodal certificate is to officer is to verify all the documents, all the certificates, and after verification they send it to NIOS, and NIOS just enrolls them, your Lordship. NIOS does not have the power to go through NIOS does not go through the documents. Now, after the result has been published and when they are demanding these documents, we see that zero marks has been recorded in higher secondary, your Lordship. This is the reason why NIOS cannot release the certificate.
So you release the certificate subject to uploading of the documents. If the documents are uploaded,
but your Lordship, it has to be before they had enrolled, like before 2017, your Lordship.
So
because the HS certificate
2022 you have exempted 50%.
Yes, your
If
Lordship.
they pass the HS certificate, they have a pass certificate, then you can issue that.
No, Lordship, the criteria was always there that you have to have a HS certificate, pass certificate, be it.
Other matters are there, but similar.
Lordship, in all the matters, same point, your Lordship.
The subsequent criteria has been subsequently introduced that you have to be an HS past candidate. Therefore, 1992 working.
So at that point of time, HS was not the qualification.
No, no.
Examination was. They are unnecessarily trying to complicate the issue by showing their authority. They are simply to say as to whether the certificate is right or wrong. Why are they going into this integrated things as to this is going to the root of my eligibility? If I do not participate, pass this, then I'll lose my job. How can they say all these things?
But then in the advertisement whereby you took admission, that has a HS qualification as a qualification.
Yes.
About
yes, but also, madam.
You joined in which year?
Before 1992, my lord.
Wait.
Here, inquiry should be restricted as to whether the certificate has been issued or not.
No. Even if we accept your contention, now they have already cleared. They have passed the HS.
Lordship, they have passed the HS after the program was over, your Lordship. So the criteria, even if we go by the 50% criteria, it was stated that the certificate has to be obtained within that time frame of the program. Lordship, it is there in the notification. We cannot improve on the case, Your Lordship. What is there on
Last
record?
date so you have placed one notification of 2022.
Yes, Your Lordship.
In my matter, they have not given the report as of today.
It is in page page 20. No, I don't know. It is not there in this writ petition.
This one.
The writ petition. That notification.
When you have clear DLED within timelines, it will be
50% was also exempt. And my humble submission should be having a.
those who do not fulfill the
It does have a retrospective effect, Lordship, given that the candidate had a HS pass certificate in 2017. Which page? One page? 15.
Report has not been given to me as yet. I think I have.
A report has not been served. Please serve. Please serve.
Prepared.
So as per this notification, August 2022,
Yes, Your Lordship.
not only 50%, it says that the minimum eligibility for admission is DLED program shall be passed in senior secondary.
Yes. Senior secondary means higher secondary, Your Lordship.
Yes.
So the candidate has to have a pass certificate. He might have a 30% pass certificate, Lordship, but has to have a pass certificate at the date of enrollment. 15 का क्या number है? क्या नाम है?
5061. And what will happen to these persons who at that point of time, since he says that 1992 when HS was not the qualification?
Lordship, in my humble opinion, submission, Your Lordship, I can say that it was upon the state nodal officer and the principal of the concerned school to have verified these documents, Your Lordship. Because the the notification is not by NIOS, Lordship.
What I am on is, they have to complete a training course.
Yes, Your Lordship.
They are in service.
Yes, Your
Untrained. At the time in 1992 when they joined,
Yes, Your
HS was not the criteria. It was suppose Madhyamik was the criteria. Now they are, for the sake of the service, they have completed DLED. You say that the certificate cannot be granted because at that point of time they have not completed HS. So what will happen?
Lordship,
What will happen to these candidates who
Lordship,
are
I'm
in
led
service?
by Mr.
Yes, Mr. Ganesh.
My lord, so far as opposition is concerned, I could not affirm it. Today I will affirm it. My client is on the way. Because of the election duty, we could not do it, my lord. This is my one point. But lordship, if we take the
main.
If we take the matter, the issue is someone obtained a degree from us. Prerequisite of that degree is class 12. Undisputedly.
Disputed. I'm disputed.
Undisputedly to me. And disputedly 50%. I say that someone has to pass class 12 with 50% on 2017, since that was the criteria. There is another notification of 2022 which relaxes the bar. Then I say it cannot be a retrospective, it has to be a prospective. That is a gray area where we will have. But so far as when someone is taking admission, whether this degree is even with class 10 or not, that's the question to be decided, Your Lordship. If it is a degree for provisional admission does not mean, suppose when I take a provisional admission in a college, like when we clarified the CAT and we are taking admission, that time West Bengal government result, Uच्च Madhyamik HS, has not been published. So the admission is provisional. I cannot say that since my law was for 5 years, one paper, because back I will give it in the next year, so I will clear in next year, and by the time I passed out, my HS is there. That cannot be a logic to be said. So the logic has to be on the date of passing, he had that with him. He had, not the certificate. means the actual date when he passed +2. It has to be a day before of the admission. So, Lordship, in this case, if Lordship goes into the facts of the case, that is not clear. They have neither made a submission. They can make a bold submission. Yes, one part is 50% or not. We will argue on that. But see, on that day, I was having this qualification of +2, and then I have to take an admission. Lordship, this is not forthcoming in the writ petition. So, Lordship, even we could not revert it. We could not deliberate on it. So we made it on a submission basis. That Lordship, if we read the notification, now Lordship kindly take up the notification of 2017 once. Brief kota. Hard copy brief kota.
Prior to that, what I was clarifying from Madam is, suppose they say 1992. In 1992, for joining the service, if HS was not the criteria, and they have joined the service, can the NIOS impose another criteria of class 12 pass?
No, we cannot.
So what does this NCT has accepted them? They are untrained, they are taking training to continue in service as per the order passed by Honorable Supreme Court. Now you say that they have to complete HS. So how they will complete within that?
Notification says, and the notification is not under challenge.
Service cannot be questioned because at that point of time HS was not the criteria.
No, Lordship, kindly see. Now kindly see this 17 notification. Give me the 17 notification.
Page number?
Page number 19 in my brief.
25.
3rd August 2017.
I have not taken. Yeah. This is item number.
There.
Yes.
Okay. Yes.
13.
Item number 15, Lordship.
No, I am in 13 right now.
I don't know, 14. 14, this is 14 going on. যে কোনো একটা জায়গা থেকে দেখাও
পেজ 8 এ লাগানো আছে রিপোর্টের এটা রিপোর্ট হ্যাঁ রিপোর্ট পেজ 8
This is item number 13, Mr. Banerjee. We are in item number 13, in which you have filed your report.
in report page 8 in report page 8 the notification that he is referring to
The 17th.
let's read that note.
Yes.
Give me the notification, please. बिल्कुल ली तुमने. Now this criteria is not done by me. It is done by Ministry of Education. It is done by NCT. I am only the implementing body. So the source of this is Supreme Court judgment. Upon that source, the decision-making body was Ministry of Education. Under Ministry of Education, delegate that job to NCT. NCT found that this should be the criteria. Then they published this. And based on there, I am implementing this. So, Lordship, first we will see the prayer of the writ itself. Before we go into this, we have to look into the prayer of the writ. Lordship, kindly see the prayer of the writ. In fact, the circumstances, petitioner most humble, the writ grant A category pay scale to the petitioner from the last date of the final exam of DEL training course, such as. I am not concerned with this. Second, a mandamus directing the respondent, especially 6 and 7, to issue hard copy of the mark sheet. So, Lordship, I can only issue the mark sheet if something is adhered to my notification. Sure, I transmit the record. Now, Lordship, there is no challenge thrown to the notification itself. If that is their criteria, that see the notification is dehorse the principle, what laid down by the Supreme Court, what laid down by the ministry. So the notification is not under challenge. Before I take your Lordship to the notification, I have to see the tenor of his writ petition. The writ petition is completely clear that he is relying, this is today, as of today, this 2017 notification is an admitted position. So parties are not challenging on that. If that's so, then Lordship, what is the criteria of 2017 document? Lordship, 22nd September 2017. Lordship has got it, that document?
No, this is third.
Recognition order. We call it as a recognition.
In
Petition.
petition, this is page number.
Page number is, Lordship, in my rate is 25. এখানে তোমাদের কত দেখো?
25. This is
Sir,
no.
My lord 13 নম্বরটা।
No, I am the item number 40.
13 তে নোটিফিকেশনটা দেয়নি তো? কাউকে বললি আমার ট্যাব ডাউন। এই নোটিফিকেশনের পেজটা একটু বলবে তোমরা? কোনটা? এই নোটিফিকেশনটা 22 সেপ্টেম্বর
22 in their matter, I think it has not been annexed. Mr. Bose has given it.
হ্যাঁ, তো যে কোনো একটা ম্যাটারে নিতে বল।
Which matter is with you right now? Which you can refer to.
Item 15.
15. Item number 15 টা দিন তো।
আচ্ছা, just a minute, I'll just indicate. 22 তারিখটা হচ্ছে page 25. তুমি page 20.
15 and 25.
Yes. 5061.
Yes.
Page number 25.
Yes.
Yes.
This is, we call it the recognition. Lordship, kindly see, whereas the matter of the recognition to the project of the proposal of the National Institute of such and such, Noida, date such and such, so SAM portal such and such. So in service, untrained teacher are considered by NCR, and NCR overpraised in as follows. And whereas the NCTE has revised direction under section 29 of the Act from the Ministry of such and such, dated such and such, the project for recognition of a diploma in elementary education program through ODL mode has been substituted by the such and such to NCTE. The proposal is for conducting online this program through the SAM portal of the ministry such and such for in-service untrained teacher as elementary level working such and such unaided private school in the country. And whereas the said project has been considered by the expert committee constituted by NCTE on order dated such and such. The combined the committee considered this project and found that the NIOS is adequately prepared to conduct the program and the curriculum proposed therein meets the requirement of such and such of NCT. And whereas in view of the direction of the Ministry of Human Resource Development under section 29 and after considering the recommendation of expert committee, the chairman is in exercise power of clause 12 of the NCT such and such grant relaxation by such and such letter dated such and such to the following provision in NCT regulation such and such for enabling such directives of HMRD for the implementation appointment of the RTI Act and this. Any provision relates to the online submission of the application portal, any provision such and such to the 18-month instead of 2 years, and the requirement of 6 months instead to be submitted this. Any requirement, minimum eligibility for admission to DL program, that is 50% marks to class 12, to the extent who do not fulfill the requirement, shall be allowed to take provision admission to the program subject to securing 50% before completion. So criteria was class 12. Relaxation was 50%, but you have to get it before the course is. So Lordship, kindly any provision in the regulation to enable NIOS to administer the program through such and such, such and such. Lordship, next, Roman 6. Allow NIOS to operate study center such and such, such and such, enable to complete the training in service commerce by around 11 lakh by 31st March 2019. So that I did. I completed. Now, Lordship, 31st March 2019, he has to give me a certificate that he is 50%. And on the time of admission, if I read 6 and 3 together, then the minimum criteria eligibility for admission 50% in marks 12 to the extent those who do not fulfill the requirement shall be allowed to take provisional admission. So, Lordship, that's why I have given in all competitive exam, all whether doctory, medical, law, there is a provisional. So, Lordship, we have allowed them. Now, Lordship, he has to fulfill this guideline 3 and 6. Then, Lordship, there is a gray area. There is a subsequent which says even that can be waived for a one time. There is a further relaxation given. I am not arguing this. But today, I have to have a clear idea, because even when I was drafting the opposition, I did not get that yes, they were plus 2 completed candidate on the date of admission. 50% or not, that's another gray area. But he has to make a positive averment to the extent that yes, on such and such, I joined the program. On such and such day, I completed. Now, Lordship, if your Lordship is now we are taking into a case where a teacher has been taken into consideration or being appointed, where he had not plus 2 degree. Because if your Lordship looks into 1995, this order was never placed before your Lordship. This 2024, Devesh Sharma, all Lordship has seen it. But if your Lordship see 1995, the first time this question arose in India against Midnapur District Primary School, which gone up to the Supreme Court, Justice U.C. Banerjee then has decided that the basic training is required for all primary teachers. Rather, a preference will be given than the B.Ed and B.Ed. Lordship, from that, in today morning, courtroom number 13, item number 3 was listed before courtroom number 13 of Supreme Court. Lordship, there I argued the point that 1995 it was recognized. We all on a sudden say that 24 is the order and based on which we started doing. No, this was there way back in 1995. Lordship, I will place that order before your Lordship, if so required. So, Lordship.
Trained, untrained.
Yes.
Trained, untrained. Trained are always given preference, even in all subsequent. These are not relevant as of now. Trained candidates are given preference. We are all with regard to untrained. In the notification of last 32,000, it is there, trained candidates. And this, not 32,000, 42,000. The notification was of 42,000, 10,000 were trained, and 32 were untrained. So, entire dispute is with respect to untrained. Trained candidates who are saying, trained candidates do not come in 2017 notification itself. They are not required to take the training. They have already done. What he is submitting? He is merely an implementing agency. He has to say whether this certificate has been issued by him or not. Now, he is trying to go into eligibility criteria. Thereafter, is becoming the employer. The employer is not saying anything. The board is not saying anything. They are okay, my lord. And my lord, the implementing agency, after issuing the certificate, after having completed everything, now is saying that no, we ought not to have issued the certificate. That is the contention that they are taking. Going into the eligibility criteria, we are working from 1992, 1993.
Okay, yes.
At that relevant point of time, plus 12 was not the requiring criteria. Then they have to say that though we do not come in this, so therefore we will not be required to do the training at all. This will be having far-reaching, my lord, repercussions.
In which of the items you are coming up with the affidavit in opposition?
Lordship, 15, 13, 15.
13 is this one. You have
13, 15. 13 we have given. 14 and 15 and 42. 15 and 42, Lordship, I will make it today.
15 and 42 I am appearing.
Lordship is right now hearing me on 15 only.
No, not on 13.
13
Hearing
and
is going
15,
on 13. For the sake
15,
of reference, I have taken up
13, 15,
13. You will be filing an opposition.
He is appearing in 13.
40. So 13, 15 and 42 are a similar question. My argument will be almost set. Now, Lordship, 42. Now, Lordship, what I am saying today, my learned friend has stated that I cannot look into while I am avoiding. I am implementing body. And when he is asking relaxation from me, he is saying that you are the supremo and you can give relaxation that it is not required.
So, wait. We'll hear the argument after you file the opposition to that. Huh? Because in his case, I have to hear him first.
Yes.
Then you make your submissions with regard.
They have
because
already taken
we are
one
stuck with
extension.
that only. 3 and 6.
But they have taken
That 50%, even if it is relaxed, whether they had the eligibility criteria on that day of having at least an HS degree. That is your contention.
I
So
did
file
not
the
have
opposition.
that.
I was,
I'm
no,
in
I was,
1992.
I was interjected in between if I can't complete that.
You will complete. Please file your opposition in 15 and 42. 42 you are also filing?
Yes.
That was the 15 and 42.
Today is the date, my lord.
There are certain identical matters are also appearing.
Which one?
47, 50.
You have taken the same.
47 and 50, no orders have been passed. Then you wait for your turn. Let us decide this issue. Mr. Lighty will argue. We put it, Mr. Banerjee, for some passover, or you'll be filing today so that he can file his reply and I can take it up for hearing.
Lordship, instead of taking it today, if your Lordship just take it day after tomorrow, 22nd will be good. Because I will affirm it, I will serve it today itself to him. So that one day
24th
time.
किया जाए देखो 24th Friday.
We will take, because there is a holiday, I think 23rd.
23rd.
23rd is an election. Kindly keeps it out next Monday then.
27th.
না 27 তারিখ I am not there. 27th I am not. Lordship 23rd এ আমরা তো সব কলকাতা। তোমার আছে। না না ঠিক আছে।
মেদিনীপুর ছাড়া চলবে না।
24th can we have it, Lordship? Friday.
24th, no, my lord. 24th, the primary matter is there in Supreme Court, so therefore I will not be there, my lord.
Tuesday.
4th में तो হবে না।
हाँ।
Madam.
8th में तो चले যাচ্ছে। 8th में। হ্যাঁ? 8th থাকছে না তাহলে 8th में তে দিয়ে তো ফ্রাইডে। Mr. Lighty is appearing in which item? 15 and
42.
14.
15 and 42.
42. এটাকে সাথে নিয়ে এসো। In 15 and 42, both you are filing an opposition today.
Lordship.
By this day you will file?
Yes. Yes, Lordship. By course of the day I will file.
Okay. 15 and 13 turning 13. The report filed by respondent in NIOS. Respond numbers 5 to 7 in NIOS is taken on record. Copy served. On the prayer of the learned advocates, list this matter on 8th. 8 to 13. I don't know. 13.
8 তারিখে
15 turn. Mr. Shiv Shankar Banerjee, learned advocate for respondent in NIOS, informs the court that the affidavit in opposition in terms of order dated 23rd March 2026 will be filed in the course of the day. Mr. Anindul ID, learned senior advocate appearing for the petitioner, seeks to. Any copy has been served?
No.
Advance copy I can.
Seeks to file a reply to the affidavit in opposition. Let such reply be filed by the returnable date. List this matter on 8th. Yours is 47 to
47 to 50 matter.
47 to 50 টাও 8 তারিখে লিস্ট করবে consecutively. এখন তো 47 কোন order?
47 and 50 also I am happy.
47 to 50.
No, there was no such direction for filing opposition, so you are not filing that.
No.
This order passed in 42, 15 and 42 will have an implication on that. So we can dispose it likewise. 42, same order. Sure. 15 and
16 also we are appearing on the same.
16, who is appearing for the petitioner?
And matter
No. 16, you are filing your opposition? No.
No, 16 there is no direction.
So 16, let it come up on 8th. Since there is no such direction, first 3 items, all these items, if I decide on that, that will have a consequence on. ঠিক আছে, on 8th May.
On it. I'm deeply.
and matter the item 200.
I'm down, go take it.
আরে ও তো লম্বা
202 and 203 matter.
No, wait for some time. Let us first decide all this.
development.
But this matter may be clubbed together, my lord.
Madam.
47 to 50 will come up on 8th. Item number 14 taraf.
Same issue. Putting কি আমরা আছি একবার দেখো না NIOS আছে না নেই তো
Who is for the DPSC? DPSC Bakura? Mr. Boisho, you are.
I am for the petitioner. Lordship, I am in the Bakura DPSC is coming, Lordship. I am for the state. I will, Lordship, let my learned friend, Lordship, place the case. I am, Lordship.
My lord, the matter relates to compassionate appointment. My lord, kindly come to page 25, page. Page 25, annexer P7. My prayer has been straightway rejected by the DPSC on the ground that total monthly family income is exceeding the initial gross salary of a group D staff on the date of death of the teacher. But no explanation has been given regarding which methodology they have applied in calculating the financial hardship. Nothing has been stated. Last occasion, my lord was pleased to direct the DPSC to file a report. First order was on, my lord, 28th February 2025, passed by the Honorable Justice Basu, your lordship. Thereafter, my lord, last occasion also the DPSC took time, your lordship, for filing their report.
Bakura কে আছে দেখুন তো লিস্টে।
But Lordship, I am here, Lordship. DPSC Bakura filed a report, Lordship. But I am appearing on behalf of the state. Bakura DPSC is coming.
Who is appearing?
Lordship, Suman De, Lordship. He Lordship court. আমার কাছে আছে গেল রে বাবা বাঁকুড়া কোথায় গেল কোথায়
Who is the applicant?
Suman De appearing, Lordship, here, Lordship.
The applicant is the son.
Lordship, just now I
Son.
give me, Lordship, a
Applicant is
report.
the son.
My lord, son.
That the final report, Lordship, if the exceptionality is given, Lordship.
Lord, I would like to file exception in connection with the report.
Without the learned advocate, I cannot take this on record.
I am giving you, Lordship.
But this is not a. How can you give of the?
Lordship, I am for the state, Lordship. There is no difficulty at all.
There are no other advocates for DPSC.
Just now the court was 15 engaged with Lordship.
Pass over. Let him come. Pass over. Or take it. Take. Poloটাও ওই দিনের প্লেস করে রিটার্ন করে দেওয়া এটা বৈশ্য টেক দিস রিপোর্ট ব্যাক 16 হয়ে গেছে 16 8 তারিখে 8 তে আসে
17 হবে 17 my lord, I am for the petitioner, my lord. My lord, the petitioner, my lord, the notional benefit matter, my lord, the home petition.
Yes.
Initially, petitioners, my lord, declared unqualified in date 2014. Subsequently, my lord, the person took
awarding of marks, my lord, petitioner became successful. And my lord, even then, my lord, the appointment was not given. Then my lord, petitioner moved a writ application. My lord, when my lord, the identical persons were given the appointment, my lord, the petitioner and some others, my lord, moved a writ application. My lord, where a direction was, my lord, passed to give appointment and considering the candidate of the 2016 selection process. My lord, that order, my lord, at page 25 onwards. And in response to that, my lord, the appointment letter was issued. But appointment letter is page 29. My lord, my writ petition number is also, my lord, 20860. My lord, now, my lord, the issue, my lord, the petitioner is claiming, my lord, notional benefit. Since, my lord, the identical benefit was given, my lord, my lord have already decided the issue, my lord. My lord.
Yes, Mr. Biswas.
My lord, the submission is not true, my lord. My lord, he participated in 2020 selection process.
20 selection process, my lord, that, my lord, at the...
My lord, he participated, my lord, 2020 selection process. My lord, thereafter, my lord, he got the appointment letter. My lord, in 2020 selection process, he joined, my lord. Now, my lord, he is asking benefit for, my lord, 2016, my lord, 2020 selection process started, my lord, December 2020. My lord, appointments were made, my lord, April 2021.
My lord, say
and my lord, the notification where, my lord, he was given appointment.
Where from I will get back.
My lord, he has not annexed all these, my lord.
No, my lord, I have annexed, my lord, the kind.
Kindly come to paragraph 11.
Paragraph 11, my lord, when the my application was not received, my lord, for my lord, only for that purpose, that petition was moved. My lord, kindly have a look at page 29. And my lord, before that, when page 25 is the my lord, petition of 2022. Order is itself speak itself. I have annexed the order.
Page number?
Page 25.
My lord, your lordship, kindly come to, my lord, page 6 of the writ petition. My lord, paragraph 12. My lord, the petitioner states in the interregnum, the Secretary West Bengal Board of Primary Education by this notice dated such and such issued notification inviting application for TET 2014 qualified trained candidate for the purpose of recruitment in the post of assistant teacher against 16,500 statewide vacancies. My lord, pause here for a moment, my lord. My lord, after this notification of recruitment, my lord, the large number of candidates, my lord, filed a writ petition before this honorable court saying that we are not TET pass candidate since we are not given, my lord, 6 marks. If we would have been given the 6 marks, we could have applied in the recruitment process. My lord, the writ petition was disposed of. Large number of writ petition disposed of by this honorable court, directing the board to consider in this recruitment process if they are otherwise, my lord. My lord, thereafter, my lord, the board published a notification in 15th February 2021. In that notification, my lord, he has not annexed. In that notification, my lord, there was a, my lord, the vacancy was, my lord, 738 vacancy was, my lord, kept aside for those petitioners who came and filed the writ petition before this honorable court. And who will be, my lord, awarding marks. And after awarding marks, if pass someone will be given, will be appointed in those 738 vacancies. That notification was, my lord, stayed, and entire recruitment process was stayed by this honorable court by the coordinate bench. My lord, against that order, my lord, board preferred an appeal before the division bench. Division bench, my lord, permitted the board, my lord, with certain observation to, my lord, complete the recruitment process and give appointment and upholding the, my lord, 15th February 2021 notification. Where, my lord, they, my lord, fall in that particular notification. My lord, after that, my lord, after awarding of, my lord, 6 marks, they, my lord, passed the TET and, my lord, considered them in the 2020 recruitment process against 738 vacancies. And, my lord, he got out the appointment. Now, my lord, he is asking, my lord, where he even did not participate. 2016 recruitment process is paying, my lord, for, my lord.
No, it's an incorrect statement. My lord, kindly have a look, my lord.
And, my lord, paragraph 13 also. Page 6.
Kindly have a look, my lord. The next, my lord, the.
Where is your report?
Let him file a report, I shall give the exception.
There was a direction. Mr. Saha, you have report?
My lord, in this matter, my lord, you will file.
In this time, my lord, I will file.
My lord, shall I, then my lord, extend the time if I can file, I shall also file.
Mr. Ratul Vishwas, learned advocate representing West Bengal Board of Primary Education, as well as Mr. Ranjan Saha, learned advocate for both the learned advocates representing the board and the state respondents seeks extension of time to file the reports in terms of order dated 6th April 2026.
ঠিক আছে কেন আগের দিন আমি ঠেকিয়েছি আমরা রাখি
Let such reports be filed by the board as well as state respondent
is not entitled
by the returnable date. 8 no need
Matter will appear
8th May.
8th May. Your lawsuit, my lord, because my lord, we are facing difficulties to get instruction from the office, my lord, because of
When you tell me by which date you are filing 11th? 11th May? Well, 15th is
15th করে দাও
15th May to
Lordship, just I file a report item 14, Lordship, pass over.
14, my lord, sorry, my lord.
14 had not been called as yet. Wait for some time. এটা দিয়ে দিন মিস্টার চৌধুরীকে দিয়ে দিন এটা
What PM, Lordship?
I don't know
13318 good deputy office
তো 14 টা দিয়ে দেবে তো none appears on behalf of the petitioner nor any accommodation has been sought for on the last occasion, that is 6th April 2026. Also the petitioner failed to appear. In view of the above, the writ petition being WPA 20376 of 2025 stands dismissed for default. All connected applications, consequently, all connected applications stands dismissed. Interim order is vacated. Urgent photostat certified copy if applied. 14 to the 14.
14. My lord, I am grateful. My lord, very sorry, my lord, that one matter was going on, my lord, as court will not.
Where is the report?
Yes, my lord. Report is, my lord, with me, my lord. Yes.
The report filed by the
Chairman, District Primary School Council, Bankura.
District Primary School Council, Bankura. Chairman. Dated 9th April 2026 is taken on record. Copy served. Learned advocate for the petitioner seeks to file exception to such report. Let such exception be filed within a period of 2 weeks. List this matter up to 2 weeks.
কবে আসবে আচ্ছা
Next.
19, my lord, I am for the petitioner, my lord. Well, here the petitioner qualified date, my lord, after the intervention of this Honorable High Court, my lord, due to, my lord, 6 disputed questions, my lord. The only difference, my lord, what your lordship has already passed orders in notional benefits matter, my lord. Here the petitioner participated in 2020 selection process. And now in 2020 selection process, my lord, appointments have been made from February 2021. Now, these petitioners have been appointed in the month of March 2022. So this 1 year I am praying for, my lord, grant of notional benefits, my lord. Now the identical issue has come up before this Honorable High Court, my lord. I have annexed the order and also the compliance. My lord, that starts from page 37.
No, your prayer is from February 21.
February 21. Only 1 year of my lord, notional benefits I am praying. And also the coordinate bench also, my lord, in identical matters, my lord, pass this order, my lord. This is the latest order.
Please go through the prayers also. Page 16 of your writ petition, it is stated February 2017.
Well, that is the, my lord, I have pleaded in the paragraphs also, my lord, I am entitled to have from February 2017, but for the timing, I am not pressing. Since the issue has already been decided by this Honorable High Court, I am praying for, my lord, from kindly consider prayer A. Well, kindly consider prayer A only. Only 1 year.
Yes, Mr.
My lord, I leave it to your lordship, my lord, and my only thing, my lord, I am not opposing, my lord. My lord, in February 20, my lord, we only, my lord, able to issue, my lord, some of the appointment letter. Thereafter, my lord, the intervention of this honorable court, my lord, we could not because of the interim order. Thereafter, after lifting of the interim order, my lord, from April, my lord, all the appointments. So, lordship, my lord, it should be, my lord, April because there was the interim order, my lord, restraining us to, my lord, give other appointment. We could not issue the
So it will be from February 2021, notional.
My lord, the last order I have seen, my lord, but we could not, my lord, at that point of time, my lord, assist the court properly. That it should be, my lord, April 2021.
April.
April, because there was a, my lord, order of this honorable court staying the, my lord, the appointment, my lord, to issue the appointment letter.
So
Recently,
the
my lord,
appointments were given from April 2021 onwards.
Yes, yes.
For February 2021, page 42 is the compliance of the previous orders, my lord. Well, they have
42.
granted.
Not
Yes, my lord.
April,
Page
May
42.
বোধহয়। May থেকে দিয়েছিলাম না রে?
Page
April
42
এ
of my
গেছিল।
writ petition, my lord. Kindly see the compliance of similarly placed candidates, my lord. From February 2021, they were granted.
Yes, writ petition page 42 granted from February.
My lord, I could not say anything because, my lord, without application of mine. Your lordship, I leave it to your lordship. Page 42 is, my lord, absolutely without. Illegible. Done.
Order passed by my lord Justice Bhattacharya has not mentioned any date. My lord, it has stated that whenever similarly placed candidates have got appointment.
This is also, my lord, identical petition like the, my lord, the last one. My lord, but he's, my lord, fair enough, my lord, he has said it, my lord, this is entitled from 2021.
In which paragraph you have stated that the other candidates have been given appointment from February 2021?
Paragraph 27, perhaps, my lord. Paragraph 27, 28. '28, my lord, precisely. Last line.
Affidavit of service filed on behalf of the petitioner is taken on record. No,
Last location I have.
Yes, correct. By the present writ petition, the petitioner seeks for notional benefits from February 2021. The petition paragraph, para 1, 2, 3, 4. The petitioner contains that he participated in teachers eligibility test within bracket in short TET bracket close 2014. But was declared not qualified. Thereafter, on the ground of several discrepancy in few questions in Tate 14, the petitioner was awarded marks in respect of 6 questions in Tate 2014 and was declared qualified in Tate 2014. Stop. Appointment letter was issued to the petitioner in the month of March 2022. The petitioner seeks notional, sorry, what get it? The other candidates similarly circumstanced have been given appointment in February 2021. The petitioner seeks for grant of notional benefit from February 2021. Hence this writ petition. Mr. Ali Hassan Alamgir, learned advocate for the petitioner, submits that the petitioner is similarly circumstanced as of the petitioner in WPA 21016 of 2024, Abdul Alim and others versus State of West Bengal and others, and WPA 12757 of 2025, Rima Necha versus versus State of West Bengal. He seeks that similar benefit be extended to the petitioner, granting notional benefit from February 2021. Mr. Ratul Biswas, learned advocate appearing for the West Bengal Board of Primary Education, submits that the petitioner has been granted appointment, the petitioner was issued letter of appointment in March 2022. He also indicates that some of the candidates have been granted notional benefit from February 2021. It is not in dispute that the petitioner is similarly circumstanced as of the petitioners in WPA 21016 of 2024 and WPA 12757 of 2025. Yes. Accordingly, the concerned respondent authorities are directed to grant notional benefits to the petitioner from the date when the other candidates were appointed in connection with 2020 selection process . This is 2020 you appeared?
2020 process, my lord. 23rd of December 2020.
Without subsequently awarding 6 marks. 8 টা same হবে. Mr. Biswas, the order is passed following Rima Nicha, where the date has not been mentioned. It has been only noted that the other candidate's appointment date, that notional benefit will be given to him. 8 টা same হবে, হ্যাঁ? এটার পরে ঢুকবে 8. হ্যাঁ, 8 টা same করে দেবে. Disposed of.
I'm deeply obliged. Obliged.
Next.
20.
Huh?
স্যার আপনারটাই স্যার
না এক্ষুনি শেষ হয়ে যাবে
যাইনি এক্সেপশনাল যাইনি
2 মিনিটে হয়ে যাবে।
হবে না আসুবি বেশি লাগবে
কি করে দেখি
But I have not received any lordship. I filed a report, but lordship here lordship directed to file the exceptional lordship. Till date I have not received.
To WhatsApp, my lord, it was circulated, my lord. To WhatsApp, my lord, it was circulated on Friday, my lord.
and they're listing the matters for hearing it out. Now they will say it has been sent in WhatsApp to take out the printout. Why this all this? Hand over a hard copy of that to them.
And on
Why
Friday,
are
my
you
lord,
waiting for forwarding it to mail or WhatsApp? Why not give it hard copy to them?
Very well, my lord, your lordship kindly allow him to file today and your lordship kindly give next week as a date.
Next week of an election.
Oh.
Where is your exception? In WPA 5443.
5443.
Just
Sir.
এটা হলো 549919147
19147 স্যার আপনার নম্বর কত স্যার
নম্বরটা বলো ওটা নম্বরটা
স্যারের নম্বরটা
544
না স্যার 25916 2025 is the lead matter.
25916.
2 weeks Bondobad.
and the other one 19147.
19147.
Yes, my lord, I am filing my 19147.
Assistant report.
আমাদেরকে
29.
কপিটা দে ফাইল করে
You have not served the copy.
My lord, I two matter 29 30 has sir.
I have received 2 copies here.
Tell me the number.
My lord, 19147.
This you have served,
Yes, my lord, not sir. My lord.
not served.
Just hand over my lord.
And 5443. Mr. Bose. 5443.
My lord, 5443, my lord, I have handed over, my lord. I have served the hard copy to my learned friend.
25916.
My lord, also, my lord, that
Yes,
has
yes,
been handed
yes,
over
yes.
and also hand over to my lord.
3 copies.
Sir is appearing for. You are appearing for.
I am appearing in 25916 for the district primary school council north.
My senior is here.
Oh. Exception to the reports filed by the DPAC North 24 Parganas in WPA 5443 of 2025, comma WPA 19147 of. Hey, আপনি ডেট দেখে রাখুন তো হিয়ারিং এটাকে আর মোশনে রাখবো না ডেট দেখে রাখুন 19147 of 2024 and WPA 25916 of 2025.
কি বলতে দেখো সবে রাখতে পারো
Copies handed over to the learned advocate for the respondents.
আজকে বলতে পারি
আচ্ছা দেখে নিচ্ছি আপনাকে জিজ্ঞেস করে নিচ্ছি
বলতে পারি আজকে আলু শুরু করে দিন
এখানে পরেই দেবে আপনি কেন এটাকে ওভারল্যাপ করছেন শুনে দেবে
জজ সব শুনবেই না
Yes, Mr. Mitro.
Yes, mine is 5
5443.
541. Now we have submitted the reply, the assessment report only this today we have served.
Item 30. Item 30.
Item number 38.
হ্যাঁ আচ্ছা এটা হিয়ারিং এ 2 PM এ রেখে দিন
Which one, Lord, sir?
8 June
8 June.
You will tell
8 June, sir.
under the heading hearing at 2 PM.
2 p.m.
Now there are no reports, nothing to be
No,
filed now.
No, not.
Copies have been served. Yes,
Yes,
Mr.
yes.
Mitro wants to say something on 8 June.
8 June.
It will come next 5
Action, sir, action.
Mine is not available before that.
Before that, it will not be possible.
Not angry.
চলে গেল শুটিং করে এই তো বললো তোমাদের
Any
26 থেকে 38 হিয়ারিং এ 2 PM
দিয়ে দে
চলো চলো চলো
Monday লিখে রাখুন 8 to 2 PM
But subject to lordship correction, my lord, one matter, my lord, is not listed in a similar matter, my lord, earlier occasion mentioned, my lord. The same matter, my
but
lord.
I cannot tag now.
Yes, my lord.
Let this matter come on 8 June.
Yes, yes, my lord, this.
38 বললে কেন 40 অব্দি তো দেখলাম This is item number
স্টেটের
20
স্টেটে কি মামলা তো বোর্ডের এগেইনস্টে
স্টেট রিপোর্ট দেবে বলে লাস্ট
State. No, this case is virtually against the board, not against the state.
The state has great time for filing report on 30th March.
I do not know. But I am ready to do the matter. If my learned friend wants to do it, do it. করবে না? ও তো বল না বাবা, আসল কথাটা বল।
দুটো আগে স্টেটের রিপোর্ট চালু করে দেবে
What is this matter about?
No. Huh?
What is this matter about?
No, this is in regard to NIOS. NIOS, I tell you, losses, he wants to the benefit like others in the respect of 22 selection process. But there are certain things, my lord, in the petition. This is totally inappropriate, my lord. No clear abundance in the petition, no documents annexed, and no documents annexed because of your losses, my lord. Since there are judgments that he has to show that he was working in a recognized school. That part of the notification of the board has been affirmed by the up to Supreme Court that he can inquire, they can inquire into the eligibility of the persons. So that's the point ultimately.
4 তারিখ অব্দি ইলেকশনে ব্যস্ত আছে
থাকবেই তো ব্যাচে give it in the after the after vacation karo fourth May kindly take it up after puja summer vacation.
Accommodation is sought on behalf of the petitioner. Please this matter on petition করে দিও Eight, opening it. Next. কি বলেছিলাম পাস ওভার ওয়েট করতে বলো ডাকছি
21 malad, I am for the petitioner malad. But the petitioner is claiming malad the notional benefit malad on the last occasion. It was adjourned on the ground malad the Mr. Bishar is supposed to take an instruction malad here malad the petitioner was subsequently declared as a malad the qualified candidate after awarding 6 marks malad in 2021 malad. Thereafter malad the petitioner participated in 2020 selection process malad. Malad, the petitioner was given appointment malad in March 2022 malad. Petitioner is claiming malad the notional benefit malad since malad February malad the 2021 malad. Since malad the similarly situated candidates were given appointment in February 2021 malad.
Your lordship dispose it out, malad. Your lordship just now, malad. One your lordship dispose it out.
Item number that was
191 কতটা ছিল এই আইটেমটা
এটা কি অর্ডার হয়েছে
19
আলমগীর
আলমগীর
এই অমিতাভ বাবু ওই ম্যাডাম এসেছিল 19 একটা ডিকটেশন নিয়েছে ওটা ওইভাবেই হবে ডিসপোজড অফ
ন্যাশনাল বেনিফিট ওরা একটা ডেট ঠিক করে করবেন
ডিসপোজড অফ
21
but I have deposited the deficit.
How many petitioners are there?
But the
Your affidavit of service?
6 petitioners malad
Deficit court fees এই অমিতাভ বাবু
অর্ডারই দেয়া আছে 21 দেখে নেবেন
ইনস্ট্রাকশন নিয়ে
আগের অর্ডারে দেয়া আছে
দাও দাও 21 টা দাও তো গো। ওর কাছে একটা হোয়াটসঅ্যাপের অর্ডার আছে, ওই অর্ডারের আমি পোর্শনটা বলে দিয়েছি কোনটা ঢোকাতে হবে। ওই 7 আর 8 প্যারাগ্রাফ মনে আছে। এখানে ফ্যাক্টটা একটু নিয়ে নিই। The petitioner, same fact. Here also 6 marks awarded.
Yes, my lord. 6 months awarded, my lord.
Same fact. Same fact. ও কি
2020 selection
পারবে না নাকি? ওটা ই চালানটা লাগবেও না, লাস্ট উইকে দেওয়া আছে। That acknowledgement not received. It has already been filed on the last date. Same order, like 19.
Grateful man.
Yes. 22.
It's a primary institution having minority status obtained in 2007 from the central government, central commission, in 2014 by the state authority. Now there is change of malot on the earlier occasion. Now, page 30, when we applied for fresh NOC from the state authority, the minority authority indicated us to submit 4 things. 1, 2, 3 are with us. Now 4 that is to be granted by the aid sanctioning authority. That's the government. Now, despite of repeated requests, they are sitting tight over the issue. Now, my learned friend has to apprise your lordship because there's short time to apprise your lordship regarding this instruction.
Yes.
But here, Lordship, I have taken instruction already received, Lordship. Additional Secretary of the Government of West Bengal wrote a letter to the DI on 1st December 2025, Lordship. But till date, Lordship, I have not received any reply from the DI. That, Lordship, I have the letter, Lordship, here the Lordship. That, Lordship, with reference to subject mentioned above, subject undersigned, I directly request him to submit a report with all supporting documents in light of the point that is stated in the guideline of the Minority Affairs, Madrasa Education Department, notification such and such, 7 days from the receipt of this letter for taking necessary action. From this, but Lordship, that letter I have not received reply. Thereafter, Lordship,
এখানে নেই এমনি একটা ফর্ম
that
আছে
here, Lordship, one Lordship form in the form the affidavit
নরমাল
in the
একটা
form.
ফর্ম একটা অ্যাপ্লিকেশন ফর্ম আছে ফর
I
ফর
think, as per my information, the form is not submitted by the petitioner.
Form.
Form.
Which form?
for NOC
NOC, anything sub document is
for
there.
obtaining NOC there is a specific
কোথায় আছে এটা আছে কি document?
না এখানে নেই
But here,
that is
Lordship, if the
part of
Lordship,
that
my learned
2012
friend,
form.
Lordship client has filled up the form, sub there is a note of objection. If we not submitted any form, that Lordship form should be submitted within a short time, Lordship. As per my verbal instruction is given, but not written instruction. If Lordship, my learned friend client submitted the form through the proper authority, I have no objection. Kindly give me the form. If he not submitted any, then he Lordship filled up the said form within a stipulated time. That is my submission, and give me some time on the basis of the Lordship, Additional Secretary of the Government of West Bengal, I am give not reply only. That Lordship, I further notice. to the
February 2023, Minority Affairs indicated certain things. Page 31, we wrote a letter on March 2023 to the Principal Secretary. We have been waiting for their response. Now, well, this is being submitted for Lordship in the month of December 2025. Some report has been asked from the DI. I believe DI as well as the other persons, they are the part of the state. Now, if they could have indicated me that form is required, I should have filed it.
Yes, what is the form, Lordship? Just now I received the
no communication since 2023, and the institution is suffering, my lord. Around 300 students
on the basis of the Lordship, I 25 Lordship, I have DI, I wrote a letter to DI, but DI did not reply. That Lordship, I am further.
DI is with you.
Yes, DI is with me. But I have
Can
not
take care of the situation.
Who will provide this NOC?
NOC is to be provided by the Principal
Additional
Secretary or the Additional Secretary, Secretariat of the Education
Without
Department.
the NOC, they cannot consider.
They cannot issue. Page 30, my lord, kindly have a look. Page 30, there says issuance of minority status certificate. It's a fresh one. Now, these documents are required. 4th copy of the NOC obtained from the aid sanctioning authority. This is not for the first time we are asking for the same. We have it. Page 30, page 20. That was issued in our favor in 2014 by the state authority.
Lordship, I am Lordship, one Lordship.
And Central National Commission, that is page 19.
Directed to the petitioner to meet the Lordship Deputy Secretary, additional Secretary, and any formality has been required. That formality is submitted. That is Lordship. I think that
Kindly
is the
fix
better.
a date, kindly fix a date, my client would be there.
Lordship fix the
Yes,
2 weeks, 3 weeks.
Kindly,
first
no, no,
order.
kindly.
In the meantime, the Lordship election is going on, Lordship. I am giving it 3 weeks. If the Lordship Secretary reasonable time, he wrote a letter to the petitioner, such give me and come forward. So Lordship, it is, but time and not a
Pending since 2023. So I would be requesting before Lordship or praying before Lordship, kindly keep this matter pending, fix any day, my client would be before the authority.
But Lordship, if the matter is pending before his Lordship, then Lordship, what's the, when the, after the election, Lordship, the election, after the election,
No,
then
no,
petitioner-
let him appear before the authority.
Lordship.
You say whatever the documents which are required, apart from the letter dated 24th February 2023. If any other document is required, they will comply that.
Yes.
And thereafter you report.
My submission is the Lordship, after election is the Lordship, 4 is the Lordship over. After 5th Lordship, petitioner meets the Lordship.
I think
additional secretary. So-
deputy director are not involved in
No, no,
election.
everyone now is the election commission. Judges is also involved in this matter. Yes, election commission. What is the going in election commission?
Okay, Ashwin. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for direction upon the respondent authorities to forthwith issue no objection certificate within bracket NOC and to facilitate the issuance of minority status certificate in favor of the present lawful management in the interest of justice. The petitioner contains that petition number 1 is a government aided primary school, namely Don Bosco Primary School within bracket girls unit, having DIAC code 190713094002, recognized by competent authority. Initially, the founder cum governing body of the instant school had been under the Salesian of Don Bosco. Now the present school is under which authority now?
Assistant school. It's kindly come to page.
Yes, yes, you got it.
Page 22.
No, in which paragraph you have stated that this has gone with other institution? The Sisters of Charity and Salesian of Don Bosco have mutually agreed to transfer the management and administration to the Charity of Saints Bartolomea Capitonio on or about 8 July 2019. Initially, the minority status certificate was issued on 29 January 2007.
By the National Commission, my lord.
By the
National Commission.
National Commission.
Thereafter, 2014 by the State Authority.
The State Authority also issued minority status certificate in favor of the institution in the year 2014. After the transfer of management and administration, the new management applied before the respondent authorities for issuance of minority status certificate. On which date this application was made?
Madam, kindly come to page 29.
Made on 25th December
Various, 2020. Before the various
22.
authorities.
25th December 2022.
Yes.
By later dated 24th February 2023, the petitioner were requested to produce certain documents for issuance of minority status certificate, including NOC obtained from aid sanctioning authority. The matter is still pending before the respondent authorities. Hence this writ petition. Mr. Jahan.
Page 31 is my prayer to obtain that NOC from the authority.
Mr. Sarwar Jahan, learned advocate for the petitioner, submits that the petitioners have repeatedly requested the respondent authorities for issuance of minority status certificate as well as for NOC from aid sanctioning authority. However, after passage of a considerable period, no steps have been taken. Mr. Boisho Learned, Vaskul Prasad Boisho Learned advocate for the representing state respondents informs the court that the additional secretary to the government of West Bengal Education Department, School Education Department has already written to the District Inspector of Schools P. Murshidabad seeking for certain informations. He submits that the matter will be fixed after the ensuing state assembly election so that further consequential steps can be taken. He informs the court that in the event the petitioners comply the statutory rules, the state has no objection in issuing the minority status certificate. In view of such submissions, please this matter, 4 তারিখের পরে বলো, 11th May. 11th May. Is a brief fact or a statement of facts file record for Assistant Secretary, School Education Department. Did this. Dated date the initial. In view of the above, the petitioner is granted liberty to submit necessary documents as per requirement by the returnable date before the concerned authority. List কবে করলাম? 11th May.
Great, Lord.
11th May. In the meantime, what is the requirement? You submit all the documents and come back on 11th.
I'm good.
Next.
Yes, my lord, petitioner appeared in the state examination of 2012, and after publication of the result, the petitioner's name was not appeared. Petitioner raised it to the concerned authority, my lord, but they have not given any answer. Thereafter, the petitioner made an application under.
Thereafter means when?
My lord.
When did you file the application?
I filed 2024.
After 12 years?
My lord. I have after 12 years, but meanwhile, I have tried to persuade the concerned authority, and I have filed, my lord. RTI application, my lord. But Lordship kindly says, page number 26. Information sought, petitioner Manik Manna is selected for appointment in assistant teacher in Paschim Midnapur district. Information provided, inadequate query. Thereafter, my lord, petitioner further applied in 25th February of 2001, my lord, and the information provided, the process of such disclosure has long been over. It is the fate of my application, my lord. Ultimately, it is apparent that the concerned authority has failed to make their performance, my lord, and that's why
Which
I am
is the
on a
first
verge of-
application for before the authority concerned?
My lord,
When did you first apply? 2020?
Page 25.
This is the first application.
Not apparently.
So what is the ground for waiting since long?
with due respect, I, the undersigned Manik Manna, son of so.
Don't read that. What is the explanation given in the writ petition regarding such delay? Yes.
This is the appropriate case, my lord, where your lordship kindly, my lord, impose some cost. Otherwise, my lord, this type of, my lord, petition will be moved before this honorable court. My lord, your lordship kindly, my lord, consider paragraph 9. My lord, this is the case of the petitioner. My lord, your lordship kindly come to page 5, paragraph 9. 9. That in spite of qualified of primary teacher examination, TED examination in the year 2012, the petitioner could not get appointment letter. Malad, as if Malad, he Malad appear in the TED, he will give it, Malad given with the appointment. Later, Paschim Midnapur. Malad, in support of these documents, Malad, if he has successful in the TED examination, Malad, he has to Malad annex a document to showing that I have passed the TED examination. My instruction. Malad, in the year 2000, the TET examination of 2012 conducted in the year 2013, the appointments made in the year 2014. Malad, those who Malad passed TET, Malad barring Malad 1 or 2, all were given appointment because at that point of time the vacancy was 34,000 and the TET passed Malad number was Malad 19,000 and odd. So therefore, all the candidates, those who have passed it, were favored with the appointment letter. So therefore, no question, my lord, that I have passed it but not given appointment. But 1 or 2, my lord, the cases, my lord, I know, my lord, were not given appointment because they did not appear in the interview or viva voce. My lord, your lordship, kindly, my lord, come to page 25. My lord, he has written a letter, my lord, under Right to Information Act to the authority. My lord, he is asking, my lord, kindly, my lord, consider, my lord, the paragraph, with due respect, I understand Manik Manna, son of such and such, post office such and such, PH district, PIN such and such, beg to state that the following information is urgently required to see actual status of this matter. I am affixing 10 rupees 10 fees, court fees. I am ready to pay. In the above circumstances, respectfully pay before your honor. Would graciously be pleased to give me written information as described in the schedule below. My lord, this is the information. My lord, there is no document. My lord, that too, my lord, in the year 2020. 19th October 2020. My lord, we replied to my lord, page 26, 2020.
Yes.
My lord, everybody, my lord, were given appointment. My lord, everybody knew their, my lord, the status, my lord, those who passed the TET.
My lord, I
And
have
what,
tried,
my lord, I really
I
fail
have
to
tried at
understand, my
my
lord.
level best, my lord, for my result, my lord. But ultimately, the concerned
on behalf of the petitioner
authorities
is taken
failed
on
to
record.
consider my
Present writ petition, the petitioner seeks direction upon respondent numbers 1 to 4 to give proper information on the Right to Information Act 2005, within bracket in short RTI Act, and for issuance of appointment letter in favor of the petitioner. The petitioner contains that he passed.
My lord, kindly, my lord, kindly, my lord, excuse me, my lord, kindly also give liberty, my learned friend, to my lord, add as a party respondent, board to be a party respondent. Board is not a party at all. Neither the any official or the board even not a party. My lord, missed, my lord, my learned friend has, my lord, pointed out.
Through secretary, the first.
No, my lord, kindly see. State of West Bengal.
Oh.
State of West
Board of
Bengal.
Primary
How can it
Education.
be, my lord, State of West Bengal service to board?
Advocate for the petitioner, leave is
Already started the
granted
copy.
to add Secretary West Bengal Board of Primary Education as added respondent number 5. The petitioner contains that
Copy said this could
informs no petitioner contains. He passed primary TET examination, teacher TET examination in the year 2012. But the petitioner was not given appointment letter. Petitioner on several times requested the respondent authority for giving information of the status of his appointment. However, no steps were taken. The petitioner also made application under the RTI Act on 19th October 2020 and 23rd December 2020 for getting information. No such information were provided to the petitioner. Being agreed by such action of the respondent board, the petitioner has preferred the present writ petition. Mr. Swanspool, an advocate appearing for the petitioner, submits that the petitioner ought to have been given appointment since he was successful in TET 2012. Despite several persuasions, the petitioner was not provided with the appropriate information regarding his status of appointment. He seeks for appropriate orders. Mr. Ratul Vishwas, an advocate for the board, submit that at that point of time in the year 2013, the TET qualified candidates, excepting 1 or 2, have been given appointments. The petitioner has failed to annex any document of his state qualification. There is considerable delay in filing the writ petition. He seeks for dismissal of the writ petition. So far as prayer A of the writ petition is concerned, this is not maintainable before the writ court. since there is appeal provision under the RTI Act for preferring appeal before an appropriate authority. With regard to prayer B for issuance of appointment letter, it is found that the petitioner, though have stated that he has successfully qualified in TET 2412, but there are no such documents. There is a considerable delay in filing the writ petition, which has not been explained by the petitioner. In view of the above, the writ petition stands falls short of merit. According to WPS, such and such writ dismissed. Dismissed.
Good. Identical. My next one is also identical.
Don't worry, my lord, I am appearing for the petitioner.
Identical.
State, my lord.
It is Tejta.
Same order of it, consequence, same. Prayer is same.
Same, my lord.
Consequence is same. TET 2012 successful. Here in TET certificate and
Nothing. They are identical.
same order. Dismissed.
25.
25, I am for the petitioner, my lord.
Notional.
Your lordship,
My lord, last occasion, my lord, on behalf of Commissioner of School Education, my lord, we have filed a report. Certain points of, my lord, objection is there that.
My lord, I am very surprised, my lord, if your lordship kindly sees the report. Report says the matter is not similar to Pilebag. My lord, Pilebag relates to 6 wrong question, but the issue of notional benefit was decided by your lordship. And here, my lord, it is not related to 6 wrong question, but the issue was for the fault of the respondents. I was not given appointment in due time. I was given appointment belatedly by intervention of this honorable court. I am paying notional benefit. The issue of notional benefit has been decided by your lordship. That they have said nothing, only said Pilebag is 6 wrong question. The issue is different. Kindly see the report, my lord.
Your case is otherwise, you have not been awarded 6 marks.
Yes.
That is the only distinction with Pilebag and this case.
Yes, my lord.
Otherwise, you are similarly circumcised.
Yes.
Only, my lord, just record my point of objection and my lord kindly pass it, lord, necessary order.
By the present writ petition, the petitioner seeks petitioners. How many petitioners are there?
Petitioners.
2, my.
Petitioners seek for approval of their service as assigned from
February 2021.
February 2021, giving notional benefit to the petitioner. এই যে ফয়চারের অর্ডারে যা সাবমিশন আছে সেম সাবমিশন। আচ্ছা ফ্যাক্টটা বলে দিই, the petitioner contains that the petitioner participated in teachers eligibility test within bracket in short TET 2014 and was successful. Subsequent thereto, the petitioner participated in a recruitment process of 2020. The candidature of the petitioner were cancelled since the petitioner was not possessing 50% in honors in graduation. You filed a writ petition.
Yes, my lord. The order I have also
A
the
writ petition was filed by the petitioner being WPA 8773 of 2022.
But here, my lord, that was candidature cancelled, my lord, at the time of verification. Presently,
writ petition I have filed petitioner number 12062 of 2021.
Paragraph 2062, yes.
My lord, page 18 and page 22.
Sort of cancel.
আলাদা
Page 22.
Yeah.
18 and 22.
Achha. 18 is filed by which petitioner?
My lord, petition number 1, Ipshita Mukherjee Da.
The candidature of the petitioners were cancelled since they were not possessing 50% marks in their honors graduation. The petitioners moved writ petitions being WPA 2062 of 2021 and 2059 of 2021. Which was disposed of on 12th, which were disposed of on 12th December 2022, and subsequent to passing of the order, the petitioners were given appointment on.
My lord, petitioner joined on 15/6/2023. Both the petition.
The appointment was given on.
Appointment was given on, my lord, on first, my lord, I'm giving Ipshita Mukherjee Da is 7th of June 2023.
Appointments were given on 7 June 2020.
26 and 7. Page 26 and 7.
Page 26 and 27.
And 30th May 2023. 30th May 2023, respectively. The candidates who appear in the recruitment process of 2020 has been given appointment from February 2021.
Yes, February 2021.
এরপরে ওই আইটেম নাম্বার 20, 21 না 19টা বললাম তো ওইভাবে হবে from the date the other candidates. This notional benefit will be from the date the other candidates were given appointment in 2026. Disposed of.
And my lord, after my joining, that your lordship has held the arrears after my joining, that is from June 2023, the arrears that has also been recorded in file box.
Okay, arrearsটা দিয়ে দেবেন, arrears. Yes, 12 কে আছে?
Deeply of.
Well, 12, my lord, I am appearing for the respondent number 2, for the added respondent.
Will not be decided by 5 minutes or 10 minutes. It is the matter relates to the this matter come from the Supreme Court also. There is a 3 order that should be placed before your lordship. It is be decided. It will take more than.
It has already been decided. The cause of action which my learned friend has
Submission before your lordship that submission should be.
In this matter, you have filed your opposition?
No, my lord. There was no such direction, my lord.
একবার দাও তো লেখো।
But twice it was taken up, time was paid for.
And paid on behalf of me, lordship. That's due to the sufferance of the illness.
This has a relevance with the other matters which has been argued.
The issue today, my lord, in this writ petition has already been decided and, my lord, dismissed by the Supreme Court. Therefore, this cause of action, my lord, already been decided. There is no new cause of action. All the issues are barred by the principles of res judicata. The issue was taken up by this honorable court, then Supreme Court. Issue has been decided, my lord, went against the petitioner.
That is not the that is partially correct, Lordship. That the situation is in different way that should be submitted before your Lordship. After the Supreme Court order, I have continued in service, and there is no suspension, no termination, and not a single substitution allowance also given. These are that point should also be decided before your Lordship.
কভার করে করবো নট টুডে দেন
Not today, very. Let no.
কেন ও আচ্ছা আমি ওয়ান মানে এদিকে But there is a direction for personal appearance. I am appearing on behalf of the alleged contender number one. The alleged contender number one, the concerned block development officer is personally present before your lordship.
But I am for the contender number 2. But she is also present before your lordship. She is the then BD.
On 17th, my lord, rule was issued, but in the meantime, on 3rd of April, my lord, the original petition applicant was died, my lord.
Okay.
Petition application is ready, my lord, today, my lord, coming.
This is a company.
Sole proprietorship.
Sole proprietorship. What is your submission, Mr. Pasu?
My lord, the submission is this, my lord, that's there is a my lord, the concerned block development officer, my lord, the fund has to be sanctioned by the higher authority. Be that as it may, my lord, I will be seeking a final opportunity before your lordship. Lordship, kindly, this is a contempt matter, and in the order, my lord, your lordship has been pleased to direct that on and from 25th of February 2022 onwards, till the date of payment, the petitioner is entitled to interest. So, my lord, in that event, my lord, a final opportunity till 18th of June. My lord, subject to your lordship's approval, lordship may kindly fix it on 18th of June, my lord. In the meantime, my lord, my lord,
No, why 18th of June? Why not prior to that?
my lord, there is some difficulty, my lord, till my lord, till my lord, 4th and 5th May, my lord, there is a difficulty, my lord. Lordship kindly appreciate.
Prior to
My lord,
vacation.
the since my lord, subject to correction, my lord, if your lordship directs early payment, my lord, the alleged contender are bound by that. But my lord, since they are entitled to, my lord,
20th May.
my lord, kindly. My lord, as an extreme indulgence, my lord, I am seeking. They are entitled to interest as your lordship has indicated in your lordship's order.
Okay, we go one by one. On 20th May, you come up with an steps you have taken and show this court that intimate this court regarding the date on which the payment will be.
No, my lord, the effort has been made. Only one thing for payment. Yes, it's not the entire amount. Lordship may kindly seize this. This is the statement of fact. My lord, initially an amount of 5 lakhs that was offered to the red petitioner prior to completion of the financial year. My lord, the petitioner has denied to accept that. Lordship kindly seize. So, my lord, endeavor has been made by the alleged contemners to make payment. Lordship kindly seize this.
This was prior to filing of the contempt petition.
Yes, my lord, that was, my lord, yes, my lord, this was offered on 12th of November 2025. My lord, let me see the day of affirmation of the contempt application.
It again on vacation for
My lord, day of affirmation
8 June. 8 June. Not 18th, 8th June.
My
Mr.
lord, that
Basu was
was
placing the matter on 8th June, not on 18th.
my lord, grateful.
The vacation you.
My lord.
In the meantime, you take your steps.
My lord, the copy of the substitution application may be served upon my client. My lord. 8th of June. My lord. ঠিক আছে দেবেন
Number 2, madam. She was the asked file block development officer. Before submitting anything, madam, I am praying unconditional apology for not appearing within time. Instead of, in spite of receiving the copy of the contempt application, my lord, during the hard tenure, my lord, this order was passed, my lord, and thereafter, before communication or receiving the order of your lordship, my lord, she made a letter to the higher authority for releasing a fund so that the fund can be or the amount can be disbursed in favor of the petitioner, my lord. And thereafter, my lord, she transferred from that post to another post, my lord.
You file an affidavit to that effect,
Right.
annexing the document.
My lord, 8th is reopening date. Can it be on 9th? My lord, 8th of June is the reopening date after summer vacation. 9th. Grateful, my lord.
Personal appearance, maybe.
my lord.
Alleged contemner number 1, Pinaki Devnath, and alleged contemner number 2, Deepanita Bormon, Srimati Deepanita Bormon, are present in court pursuant to the rule issued by this court on 17th March 2026. Learned advocate for the petitioner applicant submits that the proprietor of the petitioner enterprise has expired. On which date, sir?
কবে মারা গেছে my lord জিজ্ঞেস করছেন?
3rd of April.
3rd April 2026. He seeks to take steps for substitution. Para. Mr. Rajorsri Basu, learned advocate representing alleged contemner number 1, submits that steps have been taken for allocation of fund. As soon as the funds are allocated, the applicants will be disbursed with the amount which has been directed by this court. He seeks for placing the matter after the ensuing summer vacation so that in the meantime the process can be concluded. Miss So and so learned advocate appearing for alleged contemner number 2 submits that she was the erstwhile. She was the erstwhile block development officer of which place this is?
Islampur.
Islampur block. The contemner, alleged contemner number 2, has taken steps for allocation of funds. He seeks to file affidavit. Alleged contemner number, accordingly, alleged contemner number 1 paragraph. Alleged contemner number 1 is directed to file affidavit of compliance on the returnable date. Alleged contemner number 2 is directed to file affidavit on the returnable date. Please this matter on 8th June.
My lord, 9th.
9th June 2026 at
2 p.m.
2 p.m.
My
At 2 p.m. The appearance of the alleged contemner number 1 and 2 is dispensed with for the time being. You keep it and file your affidavit of compliance.
My lord, grateful.
These are those matters, my lord. State 2022 report, report, my lord. My lord, only 802, 803, my lord. The point is different that, my lord, we have not gone against the expert committee report, my lord. My lord, there is the expert committee report with regard to question 105 have held that there is a printing error, my lord, and we are.
So they have also raised the same question.
Only point is that we are on a single question, my lord.
Did you file any opposition to the writ petition, Mr. Sanna?
Yes.
Reply you have filed.
My lord, I shall file a reply.
ফাইল করোনি?
ওগুলো চেক করতে বলে তো সার্ভার হয়েছে না। দেখো তো চেক করো।
Lord, may I, my lord, kindly, my lord, take the records of item 805, 806. Lord, I'll make very short arguments. My lord, your lordship has heard the matter.
Wait, 802 and 803 you.
Yes, ma'am.
You will file your reply.
I shall file it, my lord.
804 who is appearing?
804, my lord, I believe they have completed their.
No, my lord, we have filed our affidavit because that was the leading matter. 806, 804.
They filed a common affidavit, my lord.
804
have
a
immediate
petitioner has
comprehensive
argued
affidavit,
or not argued.
We are ready with
Sumanta Ghosh.
You will be filing any
Lord,
reply?
804, Mr. Shaptangshu Basu has addressed.
Okay.
805 is ours. Few additional points, then my learned friend
No,
will
Mr. Basu has not yet argued.
not argue.
No, that's at the interim stage.
Interim
Before
stage, thereafter, you were not there in the last.
Me,
You were there.
Lord. Lord,
See, if he's using a comprehensive affidavit in opposition, whether you intend to file any reply. So I will record that if you are intending, then you file
we have
your
already
reply.
filed.
You file your reply.
Yes, and my lord, your lordship will see the affidavit. There is, my lord, it is.
804.
804, we have filed our reply, which is similar as 805. No, all affidavits are effectively the same. It's a question of, my lord, three things.
Look, you are not using any reply, then we'll go by that. If
Yes,
he
yes,
intends
let's
to
proceed.
My reply, my lord, within a day's time, my lord, it is ready, my lord, it needs to affirm.
2 and 3. So you are filing reply. 4, Mr. Chaudhary. 4 is Mr. Basu.
4, you have filed your reply. 4 reply filed.
Filed.
5 reply filed. We'll adopt, my lord, 4's reply.
6 you will file separate.
6, 7, and 8 is my application, my lord. In 7, I am filing the reply, but the same facts and circumstances, my lord.
6 you are not filing.
No, my lord. In 7, I am filing 807. This is my reply.
And 8, 808.
Same.
Same.
6, 7, and 8 are same.
Okay. Asun.
Adopt করে নেব অন্য রূপ করে।
না,
এটা
এটা
reply
with
না,
আছে, অসুবিধা নেই, সব
infrastructure
with আছে।
আমাদের করতে
হ্যাঁ,
হবে
এন্ট্রি
না।
করে যেন থাকে আমি বডিতে আমি বলে দেবো কোনটায় কি ফাইল করছি। Learned advocate representing petitioners in WPA
চেপে দেওয়া করে দিই, তারপরে আবার contact করবো।
29805 of 2025 and WPA 281 of 174 of 2025 seeks to file a reply affidavit in reply to the affidavit in opposition filed by the board. Mr. Jishnu Chaudhary, learned advocate, senior advocate, appearing for petitioner in WPA 29. This is 805.
805.
29744 of 2025 seeks to file a reply.
We will adopt the reply of 804.
So you're not filing?
No.
No.
No, there is nothing. I've seen his
Intend to
affidavit.
File any reply to the affidavit in opposition. Mr. So-and-so learned advocate appearing for petitioners in WPA 28297 of 2025 files his reply. Affidavit of reply which is taken on record, copy the
Copy আছে তো?
The file holo. Let affidavit in reply to WPA 29805 of 2025 and 28174 of 2025. The file when where is it? Within a week. কবে যাচ্ছে বলো? State বলে হিয়ারিং এ দিয়ে দেবো। এটা কি
negative marking আছে? That is enough. Life and death.
Hearing it detail. June যাচ্ছে।
It shows that there are
15 June. 15 June. Next.
Lord, 150 marks examination. This is not life and death for Milord persons who have graduated, trained themselves to Milord become teachers and prepared themselves for the TET examination. If they, Milord, this is their training if they are unable to, my lord, secure a job, their entire life will be different and much more difficult. So, my lord, that is the reason. And in the last 3-4 years, what has happened in the state, there is, my lord, a presumption and an indication of malafides on the part of the authorities.
We have to examine the earlier orders and the
Yes,
previous.
I'll show your lordship. So, my lord,
On
what I want to impress upon your lordship is that this is so important for these persons, their whole life depends on it. It's like, my lord, my final year LLB examination. If I do not pass, my whole life is wasted. I will not get a license to practice and appear before your lordship, and possibly I'll have to do something else.
এখন LLB ফাইনাল ইয়ার পাস করলেও হয় না, আরেকটা কি পরীক্ষা পাস
ওটা তো সবাই পাস করে। My lord, in fact, to digress, my lord, what my learned friend says is that there is a further bar examination, and all my chamber juniors, my lord, who pass out and join me, they ultimately tell me that they are sitting for that examination, they take a day off. So I ask them that in one day, how can you prepare? But, my lord, they say that it's a very routine examination.
AIB exam.
করেছে?
They are well prepared.
They are well prepared. Oh. Now, my lord, 23 questions of 1 mark each out of 150 marks is, my lord, in issue. 16, my lord, have been directly challenged in this matter. So, my lord, let's proceed on the basis, my lord, of 16 questions, which is enough in a competitive examination without negative marking for 150 marks.
Today I'm not hearing it. I'm placing it on some other day. The other replies also come.
My lord,
Because
my lord, it will be the end of the matter. My
No, no,
lord,
no.
may I just
Cannot.
take half an hour? My lord, please, my lord, may I just
No,
take?
no, no. It will be again reassessment in the other writ petitions. Otherwise, there is no
My
rationale
lord,
to
I've
putting it
seen the
along with,
affidavit.
because the
In the
issues are almost
affidavit,
the same.
yes, my lord.
Issues are almost the
They
same.
are the same. Apart from my learned friend's matter, he only wants to challenge 1 or 2 marks.
No, no, no.
His matter, 1 mark he wants to challenge.
Junior Rako will examine that.
My lord, I have prepared a chart to make it, my lord, a 15-minute argument.
Okay.
May I just?
No, no. I cannot take it prior to vacation. So on 15th June, I am placing it on 15th June. কোনো অন্য ম্যাটার রাখবে না, এটাকে কনক্লুড করে দেবো 15th জুনে।
The only thing is, my lord, right now, my lord, I don't see recruitment. But if recruitment starts, we will never be able to stop the recruitment, because recruitment is by order of Supreme Court. So we are precluded from, my lord, getting a stay on recruitment. But if recruitment happens and this matter is not decided, then, my lord, we are gone. There's no point.
No, no.
One has already started.
How you will be gone?
Because I won't be able to apply.
Which recruitment is this?
This is, my lord, for school service.
So how will be gone?
Primary.
No, no. We will decide the issue. Once it has been decided, some of the questions you say that the expert, they say that it is incorrect.
My lord, I'll tell you, lordship, what has happened without arguing the matter. My lord, we went to Justice.
Chaudhary, I'm not taking it up until they file, because you know issues are same. They file the reply. Then you don't insist upon that.
There is nothing in.
We'll finish it up, but don't linger that. On 15th June, conclude your argument.
In my matter, the reply, his matter is different.
Different point, my lord. My lord, we are not challenging the expert.
So their reply can't stand in the way of my matter.
15th.
My lord, may I trouble your lordship once? My lord, I am appearing virtually. If my lord kindly permits me, my lord, to appear virtually.
No, no, not
My lord,
permitted.
You have a state.
No, no,
No,
he's
my lord, I
leading,
am.
he's leading me in item number 807, madam.
My lord, I'll just make, my lord, a one line. My lord, just make a one-line submission. My lord, in my matter, my lord, affidavits have been exchanged. My lord, I am, my lord, apprehensive because of, my lord, the recent notification which has come up, that, my lord, if all the posts are, my lord, filled up and, my lord, third-party interests are created in respect of those posts, then, my lord, there would be, my lord, an unnecessary complication. So if my lord kindly, my lord, keeps this matter, my lord, at an earlier date, of course, subject to my lord's kind convenience, then my lord, these future complications, my lord, can be avoided. In the event my lord is not in a position to take up the matter today. Because my lord, there is a notification which has already come up.
When
And
is
my
the
lord, we can,
What is the notification?
well, the notification is, my lord, for filling up the posts of, my lord, assistant teachers in primary
That is in
schools.
September 2025.
Correct. My lord,
I
we
thought
do
in
not
any
know, my
the
lord,
notification has been issued.
Millard, September 2025, followed by Millard 1 of 19th November 2025, which is Millard annexure P14. Now, Millard, we do
দেখো
not
তো
know,
আরেকবার
Millard, how
reply
far.
দিও না, we take it up. They will filing a reply.
His matter is different.
No.
Absolutely different.
বলো।
And I have prepared this thing for your lordship's convenience. I will not make argument. I will rely on this one.
কেন্দ্রে দিও না। মে মাসে ক্লোজারের আগে দিয়ে দাও। যদি আমি 21st 18th দেখো তো।
যদি এদিকে হবে না? একটা বড় কাগজে করতে হবে, যেটা বলছে সব পেন্সিল
At glance, we have shown.
পুরোটা।
Millard, my lord is muted, Millard, I cannot hear you, lordship.
Anything, I'm finding out a date prior to that.
Oh, great. I'm so grateful, Millard. I'm so grateful. And if my lord kindly adds one line, subject to, of course, my lord's kind pleasure, that Millard, if anything happens in the meantime, Millard will abide by the outcome of these proceedings.
No.
Well,
এটা কোনো মানেই হয় না।
হবে 19th দেবো। May 230.
19th May, ঠিক আছে।
So grateful to your lordship, Millard. So great.
I'm grateful,
Well,
Millard.
this matter will be taken up separately, not with them.
Yes.
Which
Sir,
matter?
for 3 days, finding out a convenience since the issues are same, I have taken up analogously. Now you say that I'm not
question
dealing
which
with
my
them,
learned
I will
friend is
go
raising, that
separately.
question
It
is
was the
can be
submission of
carried
the
by
learned
my
advocates that you hear the matter along with all the
From
matters.
the very first date, I am saying I am.
No, I am
In
not,
the
I am not
entirety.
telling
So-
you.
No.
This has,
Our,
what has,
not
yes,
you.
what has
Our.
foreign, because I, suo motu, I have not find out and made it analogous.
No, that was the deliberation.
So on 18th May, 19th May, the matter will be heard at 2:30.
So grateful, Millard. Grateful to your lord.
Item 386 may be added to this list, Millard. It's also on the same subject matter. No
386,
separate submissions are required. It will be disposed of with this.
Difficulty is that if they say that they will be filing an opposition.
Opposition দিয়েছে, 386 is given.
Same opposition.
I don't know. I will place it not along with that, but consecutively.
One after
It's one after the other.
এটা with করবে না 386.
One matter is heard by my lord.
We
I
won't
think
even
it covers.
address.
But make it short, Mr. Basu. That is the way it is.
Short as possible.
386. What is the name of the petitioner?
Moshuna
No, my lord is now aware what is the matter about.
Yes. মৌসুনা মিত্র।
Yes,
386 টাকে ওই দিনে রাখবো ওটার পর।
Our point is this, some question is there. What is the answer of the board and what is the expert answer? What is my evidence and what Supreme Court says about that? In one page, my lord will get everything. This I prepared it.
Okay. 19th রাখো, 19th 2:30.
দেবো যখন দেবো তখন দেবো। This is the only thing. But on one page, my lord will get each question answer and the what Supreme Court has says.
Any other matter which has a like relevance, because I don't know.
No.
Oh, 386. Sir, 386 টাকে ওর পরে রাখো। ঠিক। Next.
Grateful.
তো বলো তো কে ছিল Actually, আমি সই করে নি। None appears on behalf of the petitioner, nor any accommodation has been sought for. On the last occasion, that is 30th March 2026, the petitioner failed to appear. In view of the above, the writ petition stands dismissed for default. Next. Next.
Well, I'm for the petitioner.
Oh,
43, my lord. I thought that that matter is continuing.
43. Okay, good.
My lord, this matter, my lord, the issue has already been settled, my lord. Petitioner, my lord, the father of the petitioner was a teacher of a primary school, and suddenly he became permanently incapacitated, and he made an application before the authority for appointing his son and allowing him to retire on the ground of permanent incapacitation. And my lord, his prayer was finally rejected on the ground that he does not have the qualification. He was not grade pass. So, my lord, at that juncture, many candidates were, my lord, of the similarly circumstance. They filed a petition, and Honorable Justice Samapti Chatterjee, my lord, passed an order that this type of candidates should be appointed as groups C or group D candidate in a secondary school. There is a rule also, my lord. Now I'm showing the papers. But if kindly straight away come to page number 30, the rejection letter of the petitioner, my lord. May I read, my lord?
Wait. Page number?
30, my lord.
Yes.
My lord, it is found from the relevant paper submitted by him or her via memo number such and such under reference that Samsuddin Ansari, the father of Rohim Ansari, was a head teacher of Hirapur Board Primary School, was declared permanently incapacitated by the medical board constituted for the purpose. Subsequently, Rohim Ansari applied for appointment on commissioner ground to the post of primary teacher within 2 years from the date of permanent incapacitation of his father to the chairman district primary school council Purulia, having higher secondary post certificate. Finally, the chairman district primary school council Purulia, by such and such memo under reference, sent the proposal along with the prayer of the petitioner to the directorate for consideration when the Right of Children to Free and Compulsory Education Act 2009 came into force with effect from 1/4/2010. The qualification has been given, my lord. It is not relevant. Then, my lord, paragraph 3. In the light of RT Act 2009, the Rule 6 of West Bengal Primary Teachers Recruitment Rules 2001 was amended by notification number such and such, date such and such, where under the required qualification of a candidate for appointment to the post of primary school teacher enhanced as higher secondary pass under the West Bengal Council of Higher Secondary Education or its equivalent with at least 50% marks and 2 years diploma in elementary education, whichever name is known. Then, my lord, the applicant is not qualified to be appointed as primary teacher due to lack of teacher's training and pass certificate in the teacher eligibility test. At that time, the TET was not introduced. In terms of the provision of RT Act 2009 and the subsequent amendment of the provision of the West Bengal Primary Teachers Recruitment Rule 2001 by notification such and such. Hence, in the light of the aforesaid provision of RT Act 2009, existing government notifications, the materials on record vis-a-vis the law applicable thereto, the applicant here is not eligible for appointment as assistant teacher in a primary school as per report submitted by the district director of school education, rural primary, West Bengal. You would appreciate that as per existing rule, the Commissioner of School Education West Bengal is not competent to dispose of diet in harness cases. That is different, my lord. Then, my lord, to kindly come to page number 32, my lord. My lord, in that my lord, notification, it was clearly stated that since petitioner does not have the eligibility teacher's eligibility test qualification, he is not entitled to be appointed as a primary teacher. Then this notification came into force, my lord, in 2009, to be read with another circular of 2015, my lord. My lord, kindly see Rule 21 in page 42, my lord, of that gazette notification. Page number 42, my lord, clause number 21. Clause 21 says, provision of Rule 20 to apply with modification to the compassionate appointment of a family of a primary teacher. The School Service Commission may, subject to other provisions of the rule, recommend the name of a member of the family of a primary teacher to the post of Group D, to the post of clerk or Group D staff on compassionate ground when the name of the family member is forwarded to the district inspector of school concerned, observing the formalities specified in Rule 20 through the district inspector of school to the respective School Service Commission, then such and such, my lord. On the basis of this rule, my lord, Honorable Justice Shamapti Chatterjee, my lord, passed many judgments, and my lord, I have annexed one of them, my lord, at page number 50, my lord, covering all these points. My case is exactly similar to that, my lord. At page 50
Where is the order?
My lord, page 50 is the order passed by the Honorable Justice Shamapti Chatterjee.
Where is the order? Impugned order.
My lord, impugned order is page number 30, my lord, that rejection order of the Director of School Education.
You're not praying for teacher as
No,
a teacher.
not teacher, my lord, as a Group C candidate staff in a secondary school, my lord.
Where is your application?
My lord, application has already been considered, and my lord, this is a rejection letter. And further,
No,
my
your
lord, I have made-
application for which post you have applied for?
No, my lord, initially I have applied for teacher, my lord, in the year 2010, my lord. But thereafter, because of subsequent development of this amendment, my lord, my candidature cannot be considered as group, my lord, as a teacher, primary teacher. Then, my lord, the judgment of Honorable Justice Shamapti Chatterjee came in the, my lord, surface, my lord. That on the basis of that judgment, I am also praying for similar, my lord, order. Because in that case also, my lord, petitioners applied for primary teacher, but since they are not eligible to be appointed as primary teacher, they have been, my lord, offered the post of Group C or Group D in a primary school under that circular, my lord. All these points has already been considered, and my lord, elaborate judgment was passed by the Honorable Justice Shamapti Chatterjee, my lord, concluding all these issues, my lord. My lord, page number 50 is the order of the Honorable Justice Shamapti Chatterjee, my lord. There are many judgments passed on this same score, my lord. My case is exactly similar to that. And this was also my case, my lord, page number 15. I appeared before Honorable Justice Shamapti Chatterjee as an advocate.
Again, you make an application.
My lord, after that, my lord, after passing of this judgment, I applied before the authority for, my lord, treating me in the same, on the same ground as the.
Where is that copy of the application?
The, my lord, page number 54. Praying for the similar order. My lord, second paragraph, it is stated that in the similar situation, the Honorable Justice Samapti Chatterjee in a writ petition number such and such was pleased to direct the authority to appoint the petitioner in Group C or Group D post in a secondary school. I, being similarly circumstanced candidate, pray for an appointment in operational ground as Group C or Group D post in the School Education Department, white such and such, dated Atho, and a copy of such and such is annexed, my lord. Thereafter, my lord, it was forwarded by the, my lord, page number 59.
Page 30.
59, my lord. I read, my lord, page 55. 54, I read, my lord. And 59, my lord, that application was forwarded to the Chairman District Primary School Council by the DI. But page 50 is the order of the Honorable Justice Samapti Chatterjee. That court, my lord, considered all these issues, my lord, and it was concluded.
Which was the initial application filed by you?
That is not annexed because, my lord, that was long back, my lord, in 2010.
And
yes, my lord. My lord, there is a reference into page number 23, my lord, with reference to his prayer dated 23/7/2020, 2011. He is requested to submit a copy, my lord. There were procedure to submit a copy of PPO at the earlier date to this office, and on
application at that point of time was filed within time.
Yes, my lord, within 10 years, and that is recorded in the order of rejection, my lord. Within 2 years, I have to file, my lord, page number 30.
That you have done.
Yes, my lord. And
the
that
only
was,
thing is that your considerations would be in respect of C or D.
Lordship, that much.
Who appeared for the state?
My lord, Niloy is, my lord, on behalf of the primary school council. He appeared earlier, my lord.
Niloy Mondol.
Niloy Mondol.
Mr. Bhaskar Prasad Boishu appeared for DPSC.
Mondol is the junior of Bhaskar Boishu.
40, 43.
Okay.
Yet Mr. Bhaskar Prasad Boishu, he was there in court.
Yes, my lord.
At 44, I appear for the petitioner. Kindly excuse me, my lord, I am appearing online. My lord, in the morning, my lord, I have called Mr. Kamul Mishra, who appears for the my lord, DPSC Puro in report. My lord, this is a case. May I start?
Yes.
That this is a case where, my lord, the petitioners, my lord, they made my lord, representation. If your lordship kindly have a look to the representation once of the petitioner, page 54, to the chairman of the District Primary School Council, Puro in report. In the said petition, representation, the petitioners have mentioned that there was gross illegality it committed my lord, in the 2009 selection process. Now, if your lordship kindly have a look to my lord, serial number 2 of this said representation. লিখিত পরীক্ষায় বসার যোগ্যতা মানের থেকে কম নম্বর পাওয়া অবৈধ পরীক্ষার্থী যার পরীক্ষায় বসারই কথা নয় তা তিনি চাকরিরত। মানে 3 examples মানে we have given. Thereafter মানে clause 3 in 2022 October the selection process was the process for appointment was started and ultimately it ended in 2014. Thereafter, the petitioner said that in spite of having the requisite qualification, the petitioners were ignored. Now, if Marakali comes to page 53, we made a representation to the SPIO of the District Inspector of Schools Primary Education, Purva Medinipur, which was transferred to the office of the, kindly have a look to the SPIO DPSC. It was transferred to the office of the DPSC for rendering the documents. In the, if your lordship kindly have a look to page 49, this is the application where we have page 49. Got it?
Yes.
But in the first question, 3.1, we have noted that the applicant appeared before the interview board in the year 2012 to get the appointment as primary teacher. According to the applicant Tuhin Kumar Padia, who obtained 39.29 marks in the Madhyamik examination, got appointment as a primary teacher working in Swenso Kendru. Rajkumar Pradhan and Tonusri Jana. Tonusri Jana has been made a private respondent in the present petition.
So what happened to
Please
this?
supply me. Nothing has happened. The DI has forwarded the document to the DPSC Purva Medinipur, but nothing has happened. We made a representation to the chairman as well as to the president of the West Bengal Board of Primary Education, page 56. But nothing happened. Now, if your lordship kindly have a look to
Provision, there is an appeal provision in the act itself. Why you have filed?
No, but I'm not on that. What I am
No,
on
you have
is
to be. You have to restrict yourself to the prayer of the writ petition. You are aggrieved by not getting the proper information from the officer. SPIO.
now, your lordship kindly.
It is an appealable order under the act.
True.
Have not filed any statutory appeal and chose to make a prayer which is akin to RTI 2005 to be filed before the appropriate authority. So how this
Lordship
court get into this?
May I only place page 38 once for my satisfaction? Kindly have a look to page 38. This is an information which has been given from the office of the Purva Medinipur District Primary School Council, where your lordship turns to page 39. Cutoff marks for appointment in each category. General 31.167, SC is 25.072 and others. Now, this has been signed by the chairman. This was in 2013. If your lordship kindly takes up the first page, page 38, the cutoff marks which has been quoted by the DPSC chairman for Madhyamik examination has been 2009 category wise. General is 62.25 and SC is 53.125. So, if your lordship kindly have a look to the cutoff marks for the appointment category at page 39, general is 31.167 and SC is 25.072. So, the chairman's statement is contradictory. And if my lord kindly turns to my representation, what I am on is only to, if your lordship kindly direct the chairman to consider my representation, because it is pending before the chairman, page 54. If your lordship kindly direct the chairman to consider, nothing else.
Applicable provision is there, lordship. So this petition is not made.
That is in connection with the
Not only
RTI.
that, he kindly see the lordship page 54. He made the representation before the chairman. No signature, no date, nothing has been mentioned here, and no receipt copy.
No. The RTI application was there, but the representation is
No,
also
no,
there,
he-
page
You
54.
made representation and no date and no signature, nothing is there.
See the name, Moumita Maiti, Moumita Khara, Kobita Giri, all of them have signed.
No date, lordship. Where is the date? Where is the receipt copy?
Again, any other thing? This is all.
No, well, this is my submission.
You are for the state.
Yes.
By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly District Primary School Council, to furnish the details of information sought for by the petitioner in their application seeking information under Right to Information Act, within bracket in short RTI 2005.
Mr. Mishra is appearing for the DPSC. He is present in court.
The petitioners contain that they participated in recruitment process of 2009 conducted by Purbo Medinipur District Primary School Council. The examination was held on 20th June 2010, but the results and appointments were delayed and finally published in the year 2014. The respondent authorities fixed specific category-wise cutoff marks for the written examination. However, several candidates, including one Srimati Tanushree Jana, were allegedly appointed despite securing marks below the prescribed cutoff in Madhyamik. Prescribed cutoff in Madhyamik, full stop. The information was confirmed through an RTI reply. Stop. Despite submission of several representation and seeking records under the RTI Act, the respondents failed to provide the required data. Hence this writ petition. A previous writ petition was filed, being WPA 8211 of 2025, which was dismissed as not fresh with liberty to file a fresh. Hence this writ petition. Mr. Anjan Bhattacharya, learned advocate, appearing through virtual mode for the petitioner says again, submit that there has been gross irregularities in the process of appointment. The persons with lesser marks have been given appointment. Informations under the RTI Act was sought for, however, details were not furnished by the DPSC Purbo Medinipur. He seeks for appropriate orders. Where is your representation?
My representation is at page 54. And
he seeks for
the RTI, yes, RTI.
Consideration of the representation of the petitioner dated.
No date.
No date.
No date.
No, date has not been mentioned.
No signature, nothing.
Signature is there. All of them have signed. 11 petitioners have signed with their enrollment number. Roll number. If my lord grants me leave, I will file a fresh petition.
Advocate for the. What, by leave you will incorporate date?
No. I will file a fresh representation with your lordship's order.
Whose learned advocate for the petitioner submits that for the state submits that the representation does not have any date. The petitioner seeks for details of information under the RTI Act, which is not sustainable in a writ proceedings. He seeks for dismissal of the writ petition. Mr. Mishro,
I'm appealing for the counsel.
what is your
The
submission?
interview was held long before.
Mr.
Lordship, according to RTI, we have made an application to get the information after few years. The Lordship, according to RTI Act, the information had not, the appeal will lie.
Mr. Mishro
Appealable order.
submits that
When the interview was held, when he sought for information.
information has been sought for after passage of considerable period of time. The prayer seeking for information is to be pressed in an appeal under the RTI Act and not before the writ court. Para. There cannot be any quarrel that the grievance of the petitioner as per the prayer is for furnishing details of information sought for by the petitioners in their application seeking information under the RTI Act 2005. Thus, precisely the petitioner is aggrieved by an information which was sought under Section 6 of the RTI Act 2005. The RTI Act provides for filing appeal in case of such grievance. In view of the above, the writ petition falls short of merit. It is dismissed.
Grateful.
Yes.
No, Dada.
Next.
Dada, এটা.
795.
I'm 44. I can
Lordship, I'm for the petitioner 795.
795 to your lord. Yes.
Lordship, on the last to last occasion, there was a direction upon the respondent to file a report, Lordship.
My lord, I have come with the instruction, your lordship. Let her place, my lord, I will come.
Lordship, if the report is not placed, then how will we file an exception?
You will not be filing any report.
No, I've got the instruction, I'll submit to your lordship. Your lordship may dispose it of.
Yes.
Lordship, I have very limited instructions to that the report will be given upon us and to file an exception to that report. On the last occasion also, they have not appeared, Lordship.
No, last occasion, my lord, I appeared. I personally appeared. I prayed for some time for instruction, my lord, so that matter can be, my lord, resolved. The issue can be resolved. But I have the taken instruction. Your lordship may, my lord, delegate it to the, my lord. I had it, my lord, talk with the chairman of the council, my lord. If your lordship delegate it to, my lord, we will take, my lord, appropriate steps so that, my lord, the immediate, my lord, the problem may be solved, my lord, or sorted out.
Lordship, I'm seeking for 3 weeks liberty in that case.
Few weeks.
What is your grievance that the unauthorized long absence that is to be considered? You made a representation before the authority.
There is a representation at page, my lord, 73. Or, my lord, starts from 72. My lord, it's a long absentee, my lord. Just,
Lordship,
my lord, I am indicating.
my senior is going to appear in this matter, Lordship. That's why I'm seeking liberty, 3 weeks liberty, Lordship.
ওর মামলা ওই যদি 3 সপ্তাহ সময় আছে আর কি হবে
হয়ে গেল। How many years she has not appeared?
My lord, I tell your lordship, 2022, my lord, out of 19 days, my lord, he only worked for 46 days. My lord, 2023, my lord, she was absent for 187 days. My lord, 2024, my lord, 316 days from January 24 to November 2024. My lord, thereafter, my lord, long absence for my lord. My lord, long absentee, my lord, your lordship, my lord, this is an institution in the, my lord, the proper Howrah, my lord, the city. It's a very renowned institution, Vivekananda institution. My lord, the teacher, if it is, my lord, absentee, my lord, there was a pressure from the, my lord, the guardians also to the, my lord, the authority. Because it's a very renowned, my lord, institution.
So
And
how
very
this will be
difficult as to
resolved?
run the, my lord, the school.
She has filed the so cause.
Yes, Lordship. Lordship, she has made another representation also.
No, in March 2024.
কি representation দেখি এটা দিয়ে dispose of করি নাও দেখি দাও না
So, Lordship, kindly grant us 3 weeks liberty, Lordship.
3 weeks time তোমার নিজেরই তো ক্ষতি হবে ভাই
The report will not be necessary in this regard.
My lord,
you will not be filing any report.
My lord, my lord, your lordship may dispose it of today even. If my lord,
Kindly grant us liberty, Lordship. My senior,
Who is he?
Mr. Chatterjee, Shobhushaji Chatterjee.
Where is he?
Lordship, he is out of station, Lordship.
Accommodation is sought for on behalf of the petitioner.
my lord, your lordship, my lord, any day ভাই 2-3 দিনের মধ্যে আসতে পারবে না আমি আর কি বলবো
What is the representation? You have gone through that.
My lord, the representation I have seen, my lord, is not মানে and even on the basis of that we will also, my lord, take steps so that, my lord, something can be, my lord, done or
You do one thing. You talk with Mr. Chatterjee whether this representation which he has made be directed to be considered by the board and dispose of the writ petition.
my lord, DPSC. But if your lordship, my lord, so allows, my lord, take it, my lord, tomorrow to be mentioned, dispose it of your lordship so that he may
Lordship, I
come.
need to ask my senior.
আমি তাই তো চাইছি ওই adjournment চাইছি
It is pending since 2024.
Proper instruction and come, this becomes a difficulty for the
Talks to the chairman. Just, my lord, few days, my lord, few
Now,
hours,
পরে
my lord, I asked the chairman, my lord, he will do this, my lord, everything.
Lordship, at least 2 weeks liberty, Lordship.
আরে তুমি বুঝতে পারছো না পুলিশ
okay, instruction
No, accommodation is sought on behalf of the petitioner. This matter 8th May the court after the 8th May.
এই গেল
এটা কি হিয়ারিং এ ছিল? হিয়ারিং এর আগে।
শোনো আমাকে বললে হবে না ওনাদের
Mr. বিশ্বাস learned advocate for the board submits that council submits that he has received proper instruction and no report will be filed by the board.
Yes, no report to by him.
Next.
Item 45.
Lordship,
May I place your lordship?
45, item 45, I have also told to my learned senior friend, my lord.
But I have not agreed because he on the last occasion he took.
My lord, I have, last occasion, my lord, Friday, my lord, I got, brief was given, my lord, I have sought for a instruction, my lord, I am only pays, my lord, this week time.
My lord, I tell you, lordship,
And-
my lord, I think this is just my lord, time-taking adjournment. This is covered by your lordship's order and the order of the Honorable Mr. Justice Mantha. That's your lordship's 2009 selection process. Admittedly, we are covered by those two orders. Admittedly, we were interviewed. We have come up before this court earlier, and now this is the second attempt to cover up. If I lordship want, and the vacancies are still there. If I'm
Earlier, when did you file the writ petition?
Earlier, your lordships, I give your lordships the writ petition, your lordship, page 80. I just give your lordships.
96,
Page 96, 96, 90. 96. My lord, your lordships, 96. The CAN application was filed in connection with the main matter, your lordships, from which the entire, my lord, gamut of litigations derives. The main matter, my lord, that's the lordships which are heard in terms of the order of the Honorable Supreme Court. That's the CAN 615 of 2020. So, my lord, the direction was that, your lordships, whosoever was interviewed, whosoever, my lord, came within the my lord, cut-off date, and his lordships, my lord, the Justice Mantha has allowed all these sort of applications. I can take your lordships to that also. If your lordships kindly page 245 and 246 of the second volume, I can show your lordships. Right? 245 and 246. Third volume, I think, your lordships. Kindly see, 245 first. This was of 2015 writ petition before the cut-off date. I just place your lordships that the writ petition has approached the court with the grievance that he had not been allowed to appear in division interview, although he had succeeded in the written examination. During the pendency of the writ petition by an order dated May 6, 2015, this court had directed the counsel to take interview of the writ petitioner. The writ petitioner has since appeared in such interview. In such circumstances, since the grievance of the writ petitioner has been taken care of during the pendency of the writ petition, no further need be passed hearing. The embargo of not to publish the result passed in the writ petition is vacated. Writ petition stands disposed. He moved first in 2015. Kindly see your lordships. This was moved after the cut-off date at page 246. Order dated 2nd May 2024 at page 246. Well, I'm skip over the first paragraph, second. 246. Also got that?
Yes.
The petitioner participated in the recruitment process of 2009 conducted by the Malda District Primary School Council. The writ petitioner approached this court by way of WPA number. Your losses kindly, page 245, the same writ petition. The said writ petitioner was disposed of directing the council to take the petitioner's interview. The present writ petition has been filed stating that despite interview, the petitioner's names were not recorded in the panel and marks were not awarded. Since the writ petition has been filed in the year 2015 and subsequently the present writ petition having been filed on 26th April 2024, the writ petitioners are entitled to the benefits of the order dated 26th April 2024 on the same terms and conditions. And kindly see your losses 33 and 34. All
233 petitioners are writ petitioners in WBA 121.
in CAN, your lordships, page 90. All are in the case 90.
No, in 246.
246.
Who are the petitioners?
These I am giving the example.
Okay.
That those writ petitions was disposed of 5-6 years before with the direction to appear interview, and they are allowed to appear interview, but they didn't file further before the cut-off date or immediately cut-off date. They were also allowed on the plea that they were taken into consideration for interview. Another example that was allowed by the Honorable Justice Mantha at page 246. Now, you will kindly see the another example, and they have been appointed, madam, by the Malda District Primary School Council. Page 233.
No, this cutoff of 26 April 2024, this you have not filed in a writ petition.
No. That's why I'm saying, your lordships. But kindly will look at page 245. Once a candidate came up before this honorable court that he was not allowed to appear interview. 2009 selection process interview was held in 2014-2015. Now he was not allowed to interview. This court passed an interim order directing him to allow at the interview. He was allowed to appear at the interview. Therefore, the writ petition was disposed of. Thereafter, he didn't move this honorable court. After the order passed by the Honorable Justice Mantha, he moved. He was also allowed, and he was appointed by the honorable court.
Where is that one?
That's your lordship, page 246. Your lordships kindly see the second paragraph.
His writ petition, correct. 2015, he was not allowed. Then, by the order of the court, he was allowed to appear in
the interview. But thereafter, he didn't.
Here it records in para 4. Since the writ petitioner had.
I get your losses. 25th April was the cutoff. Subsequently, the pheasant writ having been filed on 26th April 2024. After the cutoff date, the writ petitioner are entitled to the benefits.
Where is the order of Muhammad Asiruddin?
I tell you, losses 234. Just a minute, I am giving you the losses. I have annexed, I am told, Malan. Just let me. 186. It's operative part of the order 188. That's one of the main order, your lordships. Your lordships will find paragraph 13. This is in connection with Howrah. That's the for the cut-off date. Paragraph 13. In the above circumstances, following the order dated Soban Noskar for the reasons stated in respect of this Howrah, this court by consent inclined to direct that all candidates were called for interview in the aforesaid recruitment process of the 2009 and have filed writ petition until 25th April shall be entitled to appointments against existing future vacancies. So these order, your lordships, if we read, my lord, along with the order at page 230, 240. I mean, I will give another examples. And 234, no, 230, no, 246. But the single judge, the Justice Mantha was conscious of the matter. Paragraph 4. And he has been appointed by the Malad Council. I have annexed the appointment letter. Your lordships, page.
But your writ petition is not within that period. How you qualify?
Well, because I am giving Malad instances, I will show others that this has been extended only on to the candidates who have been interviewed. Now, your lordship, he has not also filed. Admittedly, paragraph 4, page 246. Yes, your lordship, he has not filed, but he has been allowed by the honorable court. They did council didn't take any appeal. take up the matter, took up the matter on appeal. Kindly see your lordships, page 248. You have been appointed. So, my lord, a similarly circumstances candidate, how can they deny your losses? Then your losses, kindly consider page 233. They are giving all, my lord. My lord, this is order dated 5th May 2015, 19164 Ganesh Sarkar. Heard both parties. It appears that the candidature of the petitioner was cancelled by the respondent authorities at the time of interview, although he was called for the written examination and selected for interview. Accordingly, the council is directed to hold a special interview for the petitioner and to produce the result of the petitioner in a sealed cover by 4 weeks from date. This order is without prejudice to the rights and contention of the parties and subject to the result of the writ petition. Then your losses matter to appear. Now kindly consider your losses page 234. The writ petitioner moves second writ petition. 13th May 2024. The petitioner participated in the process of 2009 conducted by the selection process of Malda District Primary School Council. The writ petitioner approached this court by a writ petition of 9164 of 2015. The said writ petition was disposed of directing the council to take the petitioner's interview. The present writ petition has been filed stating that despite interview, the petitioner's name was not recorded in the panel and marks were not awarded. Since the writ petitioner has pursued his claims in respect of the aforesaid recruitment process since the year 2015, notwithstanding the fact that the writ petition has been filed on 3rd May 2024.
There are two aspects of it, what I understand.
Yes, your lordship.
There was an earlier writ petition 2015. The court is of the view that since he is pursuing from 2015, notwithstanding the fact that it is after 25th April 2024, he has filed a writ petition, he has been extended the benefit. Your case is not that. You pursued it from 2015 or subsequent prior to the order passed by Justice Mantha. There was no writ petition filed by you.
Exactly that.
No.
Here also, your lordship, he didn't file.
No, in 234, which you have read.
Yes, your lordship. Since the writ petition is pursued his claim in respect of the aforesaid since the year 2015.
Yes.
Notwithstanding the fact that writ petition has been filed on 3rd May. So in between there is no proceedings. Pursued means he filed 2015 and then 2014.
234 and 246, the writ petitions filed writ petitions in the year 2015.
Exactly. Then thereafter he didn't move.
He didn't move, but taking into consideration this aspect also of 2015, the court had extended the benefit.
What we have done, instead of filing a writ petition in 2015, we filed CAN applications in connection with the main matter. That's your lordship. Asiruddin, page 90. Main matter, the panel publication matter, page 96. Kindly see CAN 615 of 2020 in connection with 2017 writ petition. This writ petition, your lordships, was disposed of by the Honorable Justice Tapabbrata Chakraborty, directing to publish the panel. That's your lordships will get it, page 58.
And the order passed in CAN 615?
That's your lordships in this order itself. I take your lordships to that. Just a minute, my lord. We were interviewed, my lord. We wanted to be added in regard to the publication of the panel. That's your lordships will be getting it. I give you lordships. Hey, we continuation page ta koto. Just I give you. আমি নোট করেছি না just a minute I lose it. Now, your lordships, kindly come to page 80. Well, after your lordships, I think your lordships kindly come from page 79. That would be better.
Yes.
By the judgment dated 11th October 2018, the appeal court allowed all applications connected with the appeals, including application for addition of parties, being can such and such filed in connection with the appeal, arising out of order passed in WP1, and the application for addition of parties being such and such filed in connection with the appeal, arising out of the order passed in writ petition number 4. Office is directed to incorporate the names of the said applications in the respective writ petitions. The applications for addition of parties filed after the order passed by the appellate court being such and such number, your lordships, the last one, 615 of 2020. Connection with writ petition number 4 cannot be entertained at this stage after the matter has been remitted to this court by the Honorable Supreme Court. The mere fact that a fresh litigation can be avoided is no ground to invoke the power under the rule. They are neither nor proper parties, and their presence is not required for adjudication of the present matter. Accordingly, the said applications are dismissed. The other applications filed on praying for early hearing also disposed of. What happened, your lordships? The ultimate prayer was that they please publish the panel. Panel was not published. It came out that the panel was provisionally approved by the government, but it was kept in the file. So went up to the Supreme Court. Supreme Court says keeping in the file, approval in the file is not a publication. So you have to publish panel then. But at this stage, we intervened in the matter that we are also interviewed. You publish the panel. Court says that you are not necessary party because that was the only direction required for publication of the panel. So, what I am trying to making submissions, so we are pursuing that remedy in connection with the same selection process, and we were interviewed.
No, what was the order passed in 615? Can.
That's that's the order, your lordships. Cannot be entertained at this stage. Page 80.
So your application was dismissed.
Dismissed. Cannot be entertained at this stage, means dismissed. Yes. But what I am saying, your lordships, because we were interviewed. Those two examples I have cited before lordships, they were not interviewed. They came up. They were interviewed. The result is not the consideration. Consideration only whether I appeared at the interview and, your lordship, whether I had approached this honorable court within the cut-off date. Now, those two matters and other matters that was, my lord, extended to the benefits of the petitioner on the plea, they continually pursued the matter. I am trying to impress upon your lordship that I was also on the same footing. I was pursuing that. Now, as soon as that I was interviewed, I got the benefit. I should get the benefit. That's my submission. Am I clear to your lordships? This is my submission. They accepted those cases.
Yes.
And there are admittedly vacancies. If you lordship wants that, I can show, my lord, I was interviewed, all that I am annexed.
Yes. Your lordship, the very fact that my learned senior friend has, my lord, shown some order that has the order of the writ petitioner who had, my lord, filed earlier writ petition. Thereafter, my lord, they have again came up, and accordingly, my lord, the honorable court had held that they are they can be, the benefit of Asharuddin case can be extended to them, and their appointment, as has been told before your lordship, that they have been given the appointment that was under the threat of contempt. My lord, the very first point that I want to place before your lordship, this person, the 615 can 615/2020, whether they are at all similarly situated with those persons who have filed their independent writ petition, and, my lord, they got a order, their petition was disposed of, thereafter they have again filed the writ petition, after filing the, after, my lord, order of the Asharuddin case, and got the appointment. Here, this person of 615 the petitioners are completely a fence sitters before your lordship. What I am trying to impress before your lordship, 615, they have made this application when the panel was not published, and as there was a gray area that whether the provisional publication of provisional approval of the panel having the effect of expiry of the panel. In single bench, the court said no, as it was not published, it cannot be said that it is at all published, and the question of expiry of panel does not arise. There are litigation. Thereafter, the Supreme Court has remanded back the matter to the single bench, and before the honorable single bench, this person had filed a CAN 615 saying that yes, kindly publish the panel, some other relief they have sought for. What the honorable single bench has done, when the honorable single bench had passed the order for publication of the panel and to give appointment to the empaneled candidate, the honorable single bench has come to a finding that 615/2020 is not to be allowed. It has not to be entertained. I am again placing that particular paragraph. 25, page 79. Page 79, it is in volume 1. It is in connection with the case that was remanded back before the honorable single bench for to have a decision on the issue of whether when the publication can be said to be at all given effect to. In that writ petition, kindly come to first page 59. For once, kindly consider page 59. There are two districts involved, the North 24 Pargana and the Malda. Yes, page 59, the cost title. The writ petition, it is WPA 21533 of 2070. Has got it. Kindly see the CAN 615 of 2020. This is the application that they have filed.
I have annexed the application also.
Yes. Now, kindly come to page 79. The order passed by the honorable single bench. Paragraph 25. Has got it. By the judgment dated 12th of October 2018, the appeal court allowed all application connected with appeals, including the application for addition of party being CAN 3206 of 2018 filed in connection with the appeal arising out of the order passed in WP1. Districts were segmented WP1, WP2 with regard to North 24 Pargana and the Malda. They segmented the writ petition. WP1, an application for addition of party being CAN 4579 of 2018 and CAN 6073 of 2018 filed in connection with appeal arising of the order passed in WP4. Office is directed to incorporate the names of the said applicant in the respective writ petition being WPA, WP1 and WP4. The application for addition, kindly consider the application for addition of party filed after order passed by the appeal court being CAN 5135 of 2019, CAN 6812 of 2019, CAN 7981 of 2019, CAN 12566 of 2019, CAN 12567 of 2019 in connection with WP1 and application CAN 1256 of 2019, CAN 10542 of 2019, CAN 12237 of 2019, CAN 4411 of 2020, CAN 4412 of 2020, CAN 6 of 2020, CAN 7 of 2020 in connection with WP2 and application can 615 of 2020. Kindly, my lord, note it down. Can 2941 of 2020 in connection with WP4 cannot be entertained at this stage after the matter has been remitted to this court by the Honorable Supreme Court. It was not entertained. Not entertained. Thereafter, this person has gone into slumber. Not a single attempt, nothing has been done. Thereafter, when this Asharuddin order was passed, thereafter similar order passed, Malo suddenly woke up. Now this writ petition was filed admittedly much after the cutoff fixed by the Honorable Malote coordinate bench in Asharuddin case. Then Malote and those persons, the instances that my learned senior friend has shown to your lordship, they have filed their independent writ petition after this Malota before the publication of the panel, as well as Malota after order passed in Asharuddin case, they have filed their independent writ petition in one time, in two time. They have never Malota thought it fit. No, we need to file a writ petition. As our application was disallowed by the court, addition of party. They are Malote, they are watching the game, they are utter fence sitter, and they are just to take the benefit of the order, though they are not at all similarly situated, they are completely fence sitters. Malote, another issue, Malote, in the Asharuddin case, Malote, page 26 to 29.
Sorry, 26.
Is the para leakage. Malote, page 186. Page 186, it is perhaps in volume 2. Volume 2. Malote, para 13, 1-3. In the above circumstances, following the order dated 9th April 2024, passed in such and such, for the reason stated therein, in respect of DPSC Howrah, this court, by consent of all parties, is inclined to direct that all candidates who were called for interview in the aforesaid recruitment process of the year 2009 and have filed writ petition until 25th April 2024 shall be entitled to appointment against exercise of future vacancy. All applications, para 14, all application for addition of party above until 25th April 2024 in subject writ petition are hereby allowed, disposed of. The cutoff is 25th April. Application addition of party in this writ petition they have filed 25th April. Their addition of party was rejected by the court, and there was no attempt since 2021 onwards either to Malote. Yes, either to Malote by filing a independent writ petition, though at that relevant point of time, other candidates who are not empaneled, who are unsuccessful, they are pursuing their remedies by filing their writ petition. And Malote, and as thereafter this order has come, and as there is a addition of party in connection with those writ petition, the court had allowed. This writ petitioner, Malot, is total fence sitters, and they are just try to malote take the chance. They take the chance to malote to get an order from this court, though they are not at all similarly situated in the case. And malote, another thing, on just the coordinate bench who has malot authored the parent order, Asharuddin case, that court also malot had filed had dismissed the CAN application, even though that was filed within 25th April 2024 for addition of party. That CAN application was also dismissed on the ground that they on একটা case they because in their writ petition, the writ petition was dismissed for default, and the writ petitioner in the writ petition, the main writ petition, they have restored the writ petition, but their CAN was there as an addition of party. At the time of restoration, they were not there. And as the court had restored, the court had also extended the order of our Masharuddin in favor of the main writ petitioner. Thereafter, the person who are in the CAN, they have came to the court saying, we are also there, kindly allow my application and give me the order. Court had dismissed those application also. This is there, Justice Mantha has passed this order. In this case, my lord, this writ petitioner is not at all, my lord, a similarly situated candidate. They are sitting in the fence, they are watching the game, and my lord, when when this writ petition was filed, my lord, this writ petition was filed
25th July 25.
Yes, my lord, 2025. Cutoff is 25th April 2020, my lord, 2024. Even after the honorable, the coordinate bench, the Justice Mantha has put a cap regarding entertainability of the writ petition, even though writ petition was pending, but it was not moved. The court had said, no, don't entertain. I will not allow entertainment of any further writ petition. There was a modification also. My lord, as of now, this writ petition is a complete fence sitters. They are watching the game, and this writ petition, they are not entitled to any kind of relief, because my lord, fence sitter has no right to, my lord, of any kind of my lord, relief from the court. And my lord, this writ petition is filed much prior to the much later than the my lord, cut-off date. Let it be. This writ petition should be dismissed.
I deal with my learned friend's concise submissions. Three points he have raised. In reply, I can't take your losses other points. Earlier, present writ petitioners did not file any independent writ petition. This is. Well, my learned friend makes these submissions. I respect him, but without taking your losses to the facts of the case. Well, I will take your losses my CAN application. Fortunately, unfortunately, we were interviewed. De novo interview process in 2014-15. In the 15 in Malda district, 2015. Those two examples I have cited before lawsuits, they were not interviewed. So they had the occasion to come up in the 2015. I didn't have, because I was interviewed. Why should I come up before this court? So they did come up. Well, that can be a fortunate fact that they were not called for interview. That's why they had to come. That's a fact for consideration. This cannot be a logic. Why should I come up with the independent petition? What happened, your losses, 2014, after 2015 selection process, my lord, in interview, they didn't public council did not publish the panel. Some writ petitions were moved. My lord, writ petition moved, please publish the panel, because this has been approved provisionally. And this fact also came into normal in course of the pendency of the writ petition in 2017. Then, my lord, certain directions was passed. This was taken, your losses, to the division bench. Division bench, some of the candidates applied for addition of party. Yes, that should be published. Division bench allowed. The state and council went up to the Supreme Court. Supreme Court didn't accept their plea. On the contrary, Malad framed certain points. On these points has to be decided whether publication, non-publication of the panel in the malad total media, can it be construed as a publication of panel? If not, publish the panel. Then again come up for rehearing before the same writ petition, 2017. When we moved an application for addition, the court said, no, after the division bench, you are coming after the Supreme Court. What is the necessity of it? Because this is only publication of panel. At that point of time, nobody's right accrued. Then publication of the panel was published. I'm saying, Malad, then I will take your losses to the documents. Then the panel was published. As soon as the panel was published, appointments were made after giving the supernumerary post, but a number of writ petitions were moved. Number of questioning the panel itself. Now, those writ petitioners, Malad, Justice Mantha was pleased to dispose it of. The series of allegations. Allegations means, Malad, somebody got 60, but 35% marks who have got, they were appointed. Then Justice Mantha said, Malad, I appeared for the not 24. What to do, Mr. Sannal? Would you accept all the petitioners to give the appointment, or should I cancel the entire thing, lock, stock, and barrel? Malad, on instructions, I accepted that. This is the situation. Malad, now consider it. Those examples I have given to your lawsuit, page 246 and 236, maybe the page number wrong. Those were also not parties before Justice Mantha. Those were not also earlier only for the allowed to appear at the interview. How those facts, independent writ petition becomes a material fact for consideration. Now, I have come up your lawsuits after Asauddin, admittedly. They have also come up. Justice Mantha was, Malad, kind enough to extend that. Look, they were also come up, they were not interviewed. What's your illegality? You have appointed the lesser qualified candidates. So they were also not interviewed. So they are pursuing. So what I have come up, I come up for publication of the panel. You kept the panel pending. Then you'll see publication of the panel. Then I'm saying, I'm similarly, I'm not a fence sitter. If how they are not fence sitter, then your losses, I am putting a question to myself. After 2015, when they were allowed to appear at the interview, they didn't move this court for publication of panel. At least I moved it. They didn't. They sat tight. They came up also after the cut-off date. But I'm trying to deep into it. When they come up, after 25th April. Malad, 15 days, 20 days, the difference cannot be a matter of consideration. At least, Malad, that should not be before the writ court. What I am saying, your lordships, they did not move it. Justice Mantha said it. So that they're pursuing. So I am also pursuing. I came up when they came to know that the panel was not being published. I got interview. I sat for the interview. I passed the written examination. But the appeal court says, what is the necessity of it? Because prayer was only publication of panel and consequence appointment. So the panel didn't, at that stage we come up. Now your losses kindly see.
But there is another statement which observation has been made while dismissing the application at page.
I got your losses.
79.
At this stage, kindly page 80, cannot be entertained at this stage after the matter has been remitted to this court by the Honorable. At this stage, your losses. So I can come up. Subsequently, the mere fact that a fresh litigation can be avoided is no ground to invoke. What I said, tell your losses. This is a publication of panel. If somebody gets publication of panel, suppose I have not moved even the addition of party application. Suppose, my name would have been in the panel. I could have got appointment. So that's this Supreme Court says the single judge, Justice Chakraborty at that point of time. This is a publication of panel. Unless you are in the panel, you will not get an appointment. If you are in the panel, you will get an appointment. Kindly see the application for addition of party of the other parties were allowed. What are the difference? Because I came little late at that point of time. And then your losses will find they are neither necessary nor proper parties. Why this observation made? Because for publication of panel, my presence was not necessary. Because already that point is being heard by the Honorable Court. So this was the point, your lordships. So how can my learned friend describe me as fence sitter?
We have to limit ourselves to the twin condition. Suppose as you are submitting, there might be some cases where they have been called for interview, they have not filed any writ petition. The court does not say so that all persons entitled, they should be given appointment.
Court,
So all persons should be given appointment. Court doesn't say so. Court says that the persons who have filed writ petition and they were called for interview, these twin conditions, if satisfied, you give appointment. In your case, the court single judge says that mere ground that you have to file a fresh litigation, so your prayer for addition of party is to be considered, it has been turned down. This plea has not been accepted. Now in 2021, at that point of time also the panel was not published.
By this judgment, the panel was published.
So after 2021, you did not seek for any other relief?
Admittedly. Now, Malad, if I...
In 15, you say that they were not called for interview, that's why they filed the writ petition. But there has to be something that you have been given appointment. You could have sought for after 2021, that the appointment has not been given.
Malad, if this fact is taken into consideration, does it make difference with those two cases with my case? Malad, at that point of time, I was called for interview. So I didn't have any occasion to come up. They were not called for interview. They come up. How can be a relevant fact for giving them the relief? Just because they were denied, they came up before the Honorable Court. And I was called for interview, I did not come up. But I came up, your lordships, in the petition in 2017 that for publication of panel. So all that was needed for consideration, that earlier I moved this court for the relief. They were also not impaneled. They were also not impaneled after the interview, like me. But they got the benefit. Just because it's just like a toss. Just because they earlier not interviewed, by the order of the court were interviewed, and that's an attempt to continuously chasing the matter. Then my CAN application, they were not allowed to interview, court allowed. But my CAN application for publication of panel, court said dismissed because I moved after the division bench.
Where is that application?
That application I take, your lordships, to page, I have annexed to page. Just to give you a lordship. 165. 166 if your lordships get. Skipping over the cause title, page 165. It cannot be my humble submissions. I request your lordships to kindly consider this. Page 166 is the relevant. I place it to your lordships. Para 2. Your applicants state that they are the bona fide participant of the recruitment process initiated by the government through notification dated 2009 for the post of assistant primary school teacher within the territory of Malda district. Subsequently, by modification and cancellation of the government order, or by issuing order dated 21st June 2012, the state respondents had started the selection process afresh by taking written examination from amongst those aspirants who had participated in the earlier written examination, connected in connection with the recruitment process, which commenced in the 2009. Your applicants state that the said recruitment process initiated pursuant to the order dated June 21st, 2012 is still afoot by way of non-publication of panel and non-implementation of the published panel in accordance with law. And as per the terms of the said order dated 21st June 2012, the state respondents have categorically intended and mandated that the said de novo recruitment process must be concluded by giving appointment to eligible candidates based on the panel published specifically within 19 days from the date of issuance of the order. The applicants state that assailing the recruitment process initiated in the 2009, which was subsequently modified in the 2012, through an order dated June 21st, 2020, writ petitions concerning the same subject matter was filed before this court from 4 districts, Howrah, Malda, North 24, South 24. After due adjudication of some of the writ petitions has been disposed of, while a few are still pending adjudication. Your petitioner state that the bona fide candidate participants of the said recruitment, including the applicants, are struggling for fair and transparent selection process, for last couple of years, incessantly. This paragraph I will take your losses with reference to Justice Mantha's order. Incessantly, and have time and again visited the chairman of District Parliament Malda seeking redress to their grievances. But all the while, they had been asked to wait for the final settlement of the dispute in court, but they were never provided with the details of the case pending before the Honorable Court. In the course of their continuous struggle for fair selection to the post of assistant teacher in the throughout the district of Malda, the said participants, including applicants, came to know that one Ranjit Jha from section of candidates from the district Malda, and upon inquiry found the two writ petitions still pending adjudication before this court, one of which had been preferred by the said Ranjit Jha. After gathering such information, the applicant obtained the copies of the writ petition and going through the same have apprised themselves of the subject matter of the dispute and the relief sought for by the petitioners through such writ petitions. Our applicants have submitted that after going through such writ petitions occurred to them that the applicants are on the same footing as the petitioners, having substantial jural relationship with such writ petition because all of the victims are arbitrary action by the Malda, and prayers of the applicants are the same that of the writ petitioners, which is to pay for a direction upon the state respondents to publish the panel of the selected candidates as effective culmination of the recruitment process initiated in the 2019 process, District Malda. Before proceeding further, I just make my submissions. Those two candidates who are not interviewed, they came up. They were interviewed. So after the interview was held, our panel was not published. So we are on the same footing. They didn't come up also. But we came up at least. But my submission would be my case is more better because after being interviewed in a proper manner, the panel was not published. We made allegations that there are discrepancies in the panel. So we wanted to be added. Court did not allow the addition because one has to adjudicate the issue. Issue is publication of panel. Unless the panel is published, no one gets a right to be considered. But can visualize some of the applications was allowed before the division bench prior to the going of the Supreme Court. Well, it's not necessary that they have been appointed. Maybe they have been appointed subsequently because of the Justice Mantha's order. Because those only initially in the parent panel, they were appointed by the councils.
The panel was published on which date?
Panel was published, I give you losses, in the month of February 2021. And the second one, February. And the second one, your loss is 24. Justice Mantha's order, they prepared a panel and published. That's 24. Now, therefore, your losses kindly consider.
So your grievance is since February 2021. You are not in the panel.
Not in the panel. But I didn't move it. Probably that's bothering your lawsuits. Now your lawsuits, that's a point. What about those two? Did they move? Then why did you consider them? You accepted that order. Just, my Lord, Justice Mantha said they are chasing. You didn't argue that they are not chasing. Because you satisfied yourselves that they are coming within the same criteria. They didn't also move it. I must have an occasion, my Lord, after 25 years, large number of petition was moved. Somebody moved, somebody didn't. Somebody became frustrated, my Lord. Somebody, 2009 selection process. One getting appointment in 2024. Some of them have got, my Lord, for 45 for 50 years of age. So that's not the consideration. Now your lordships kindly see the consideration of Justice Mantha. I am going between the lines of the order. Justice Mantha's order, page 186. Your lordships kindly consider. This starts from 186, but that's a huge cost title. Your losses kindly skip over. How just I'm sorry. Just the first order, not even Malda. 287. I'm sorry, ma'am. This is the first order. Operative part 290. Your losses kindly. A unique paradoxical situation has arisen in which this court is required to, by consent of the parties, deviate from the laws of practice and procedure followed under Article 226 of the Constitution of India. Well, kindly consider how much consists of your lordships, what he is doing. Then the facts of the case, Malad, I do not repeat this because in my application I also have stated it. Kindly your losses go to. Now kindly come to your lordships, page 292, paragraph 7. Malad, 291, paragraph 6. After the de novo examination in 2012, a panel was prepared of successful candidates. Appointment letters were issued. Several writ petitions challenging the selection process came to be filed since the year 2015 until 2023. I'm gonna pause here for a moment. Somebody filed questioning the selection process in 2015. After the panel was published, now I'm putting a question to myself. Does those writ petition remain to be considered? Because the panel was published, someone has to consider the panel, question the panel, but they were also appointed because writ petition was pending. The ground of challenge was that ineligible candidates were granted appointment. On June 9, 2020, the coordinate bench found irregularities in the recruitment process of the year 20 committed by Howrah. Kindly see what are the irregularities. Person who did not sit in the written examination in the year 2009 were allowed to sit in the examination. Persons who are not qualified to sit in the examination and sat in such examination were allowed to once again sit in the de novo examination. Several of such disentitled candidates were impaneled and issued letters of appointment. By the order dated June 9, 2023, coordinate bench directed each of the petitioners in the fourth writ to be appointed and absorbed as teachers under the Howrah District Primary School Council. Before this court today, the petitioners in the subject writ petition seek the same benefit as to those petitioners. 11. Learned Counsel for the DPSC Howrah submits that the coordinate bench in its order dated June 9 committed error in entertaining the writ petitions after 11 years of the conclusion of recruitment process. Sometimes when appear on behalf of the writ petition, we take certain stereotype arguments. Fence sitter, didn't come earlier, didn't move earlier. Sometimes I do not blame anyone. Having appeared, I also take it. Because it's like a plain to your losses when you refer written state of dismissals in the proper form, not maintainable, acquisitions, barred by principles of acquisitions, whatever, like that. 12. This court cannot brush aside the argument of Mr. Sandal. The delay in approaching the court, even against an apparent illegality, negates the right to relief. The law on the principle of delay and latches under Article 220 is now well settled. The only consequence that would follow is cancellation of the entire recruitment process. Such cancellation is supported by the settled principle of law that fraud unravel all. Even a delayed approach to court for undoing a fraud and revoking a fraudulent benefit can be entertained, and such delay will not stand in the way of addressing an illegality arising out of fraud. On the other hand, it would be extremely onerous and unfair to cancel the appointments made in the year 2012 and after a period of 12 years, even they are found to be improper. So, the Honorable Judge thought himself that he is in between two. If I find fraud, then I have to cancel all of them if I can't relieve them. The other consideration comes to the sympathetic consideration, equitable consideration, that they are working for 12 years. They have got their families now. If I cancel their appointment, what will happen to them? So, in both of them, the relief that can be extended, give them the relief appointment, those who have come out. That's your lordships. Your lordships will find one after another. What are that? Your lordships will find all that. I just give you lordships. Now, Your losses will find paragraph 18. This court as an exception is inclined to entertain an application for addition of parties and allows the same. There were in this writ petition the addition of parties. They are asking for the same. The court allows. Sometimes the generosity of the honorable judge also gives relief somewhat. Kindly your lawsuits. Sometimes. And sometimes to us off that this should be stopped here, the courts become sometimes my lord hers. Maybe knowing full well that I become hers. Then your lordship, I made it absolutely clear that this part was very special facts and so on, it shall not be treated as cited, all that. But even then, after this, your lordships, Malda District Court's order was passed. That is at page 186. Your lordships, kindly. Starts from the judgment portion starts from page 188.
Yes.
Now your losses will find the same thing. Paragraph 9. In a page 189. In a decision of coordinate bench in respect of the Howrah DPSC, by order dated 9th April 2014, a consensus was achieved by consent of all the parties, including the Commissioner of School Education, to accommodate the petitioners in all writ petitions filed up to 31st March 24 to be appointed against available vacancies. The said consensus based on order dated 9 June. That's now I placed before your lordships. It cannot be said that there were no irregularities or improprieties in the recruitment process. That's what showed the court. So this is the basic thing. Total irregularities. Then paragraph 12. In the event the irregularities are accepted, the entire process is recruitment is liable to be interfered with. That would cause prejudice to candidates appointed or working from some years. There is no way segregating the lawful and unlawful appointments. In the above circumstances, following the order dated such and such, I'm inclined to direct all the candidates who are called for interview in the aforesaid 29 and have filed. Therefore, my lord, the initial order was 31st March, my lord, filed up to 31st March.
That was in respect of Howrah. Howrah.
Howrah. Now, therefore, your losses, the process is same. 31st March was Howrah, then for 25th April. Now, my lord, now dear losses, my learned friend says, I sum up my submissions. I didn't know independent writ petition. I didn't any cause for coming up independent writ petition before the publication of the panel.
After you have the...
My point is that thereafter they had also a cause. They didn't come. This is not the case that they have immediately come up questioning the panel. Then how could you accuse to their case before the court? And court, your losses, kindly see the grant when the granting relief. I must take your losses, those two orders, page 240. First, your losses 246. Kindly see paragraph 4. Well, since the writ petition has been filed in the year 2015, I'm pause here for a moment. My submission, substituted by my submission, can application was filed in 2017 or 2020 in a pending writ petition for publication of panel. What makes the difference? One was interviewed, one was not interviewed, but all of them after publication of panel to be considered on the basis of the panel. So I came up Paul Muller for publication. Subsequently, the present is having been filed. This is after cut-off date. Admittedly, they were given relief by the court. Now, how can I be said the fence sitter? On what principles? I'm equating. I'm making comparison with the two.
Yes.
So they cannot do it, my lord, being an authority. Where is it? My lord, your lordships kindly see, my lord, page 273, one of the order. Another order. Kindly see, my lord. I am giving the facts. He admittedly came, my lord, 2023. My lord, kindly see the facts of it. The petitioner originally moved a writ petition and was permitted to appear in an interview. The letter of interview such and such. It is stated the petitioner did not come to the interview. The writ petition filed in thereafter March 23. The petitioner is therefore covered by the order.
This is prior to the.
Prior to, I'm on that. According to the council's case, he didn't appear at the interview. Even then, the relief was granted. Covered by the dates, I have understood that. But he didn't appear at the interview. What about that condition? So, the best consideration was that the illegalities was so galore. One has to show your lordship that somehow he approached this court.
So as per you, the twin condition was not an absolute one. The court has, in the facts and circumstances, has extended the benefit.
It's not that I'm coming, Malad, just years to get it. And you think, Malad, you lost the vacancy. Therefore, I was not watching your losses. And just
185.
185 your losses, kindly come up your loss.
এটা ব্যক্তিগত এর থেকে 312 জনকে অ্যাপয়েন্টমেন্ট দিয়েছে 219 পেজ
But page 185. But for this purpose, the government granted specific vacancies. It's not that the first phase vacancy is required to be considered. Malad, your losses, this is a letter dated 2nd November 2022. This is on the basis of Malad, this is on the basis of Malad, RTI application that after second Malad list of merit panel, how many vacancies are still left? Malad, your losses will get the subject matter status of joining or non-joining report of the primary teachers appointed in respect of the process for appointment of panel candidates of recruitment for 2009 by district. Now your losses will find with reference to the subject side, I am undersigned to hereby inform that the status of joining and non-joining report of the primary teachers appointed in respect of the process for appointment of the panel candidates of recruitment process 2009 conducted by Malda DPSC. Status of category-wise joining candidates is given below. Total 857. Has you also got that one? 85. Status of category-wise non-joining candidates given below. 431.
What is the present status now?
Present status, your lordships. Page 219. If your lordships kindly consider. 219. ওটা কি থার্ড বুক নাকি থার্ড বাস থার্ড হলে আমাকে নিতে হবে মানে থার্ড ভলিউম পেজ 219 মানে your lordship has to consider 185 and 219 side by side. This is of 25 letter of the chairman. It is hereby notified that the appointment letters in favor of all 312 have been issued and dispatched to the address. So if your losses we deduct 312 from 431, my lord, 119 are still available. My lord, my instructions here, lordships, that thereafter further 8 appointments have been made and still vacancies are 111. We are 12 in number.
thereafter, my lord, this merit list, this is not a panel, this is a merit list. My lord, 312. Thereafter, because some of the candidates who are having the benefit of Asharuddin order, my lord, they have not been given. They are not, my lord, appeared in the counseling or something else, because after this order, Asharuddin order, my lord, there was a direction that they shall give their credential, everything. My lord, we have issued a notification, those who are the main writ petitioner in the Asharuddin case and those who have get the order of benefit of the order of Asharuddin, they should come and produce their credential. My lord, some of them not come, but they have filed their contempt. And my lord, as there is an order existing, my lord, and contempt is pending, my lord, we have given them appointment. My lord, the vacancy 312, and thereafter many vacancies are there. Out of the my lord, left out vacancy, there are further appointment. As of now, my lord, the exact vacancy we need to take instruction. Not 100 and something, my lord, that is not there. We need to take instruction.
Well, there.
And my lord, because every time, my lord, only 312 was given. There are the remaining vacancies is there. There are my learned friend, the junior to Mr. Shanal, my lord, they have filed their contempt. And my lord, 30 near about 30 to 30 appointment were more given to them. Thereafter vacancies are less. Need to take instruction to that effect. If my lord want to get the exact figure, I need to take instruction.
Even if you get the instruction, the order records that either from the existing vacancy or future vacancy. So future vacancy, that what is there.
Yeah.
You get instruction?
Yes. And my lord, in the operating portion,
রাজার বলে কি করবে রায়
let it be, my lord, I
যদি ওটাই বলতে চাস
Orders place on Friday for orders.
My lord, I am not able to, because I am going to cast my vote. I am not there.
You will not.
আরে ও বাইরে থাকে তো অন্য ডিস্ট্রিক্ট তো ও ওখানে তো
My lord, let it be on Monday or
Monday.
next Friday, if my lord will be kind enough.
Monday. Heard Mr. Shubir Sandal, learned senior advocate for the petitioner. Mr. Abhishek Prasad, learned advocate for DPSC Malda, also places his points of argument. Please this matter for orders. Is this matter on 27 for orders?
But in the meantime, I take the liberty of your lordships. If I get pattern the point judgment, how this I will give you with a copy to my learned friend.
And
Can not recorded that you have concluded.
No, no.
I have heard you.
All right. That's much obliged.
Let him come up with the instruction. How many vacancies you been there? For orders 27. Propose the grant. State. Give your name.
I also want to cite some order, my lord. On that day I give.
Well, before rise on in one of my matter, your lordship has issued rule in contempt matter. My lord, the difficulty is that I have lost my file. Now, my lord, your lordship, not in the list. But few days back, your lordship has issued a rule in one of my matter. Now, my lord, 30th March order was passed. Now, I have lost my file. The requirement is that I have to give them 3 copies for issuance of rule in the rule department.
Get the certified copy.
But certified copy only I can get if the file sent down to the Mandam even only. Otherwise, I cannot get it. That's the whole difficulty.
Order show you
1985.
You give the number. আপনি ওটা যদি না হয়ে থাকে ওটাকে পাঠিয়ে দিন। Give the number, you make your application.
Extremely grateful.
ঠিক আছে। হ্যাঁ সার্ভার হয়েছে তাহলে তো ঠিকই আছে রেকর্ড যায়নি আপনি দেখে নিন যদি না গিয়ে থাকে 5th May তে আসে ঠিক আছে it will be sent you make your application.
Extremely grateful.